Good morning, everybody. Happy Super Friday. Welcome to TCF Live. It's a Super Friday, so let's get started with Judge as plain spoken as you can get, Mr. O'Donnell.
Does that medication that you took yesterday affect your ability to understand what's going on today?
No, sir.
Have you ever been treated for any mental illness?
No, sir.
All right, did you get a copy of this indictment?
Yes, sir.
My understanding you're going to plead guilty to aggravated possession of drugs of felony 5 as well as the forfeiture specification. Is that your understanding?
Yes, Your Honor.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, let me know. If you want to talk to Mr. Fatika some more, let me know that, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes,
Are
sir.
you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, I am.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to this charge?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes, sir.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or to community control.
Yes, sir.
Now, the offense of aggravated possession of drugs is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
If you plead guilty to the forfeiture specification and you're voluntarily giving up the items listed in the specification, do you understand that?
Yes, Your Honor.
You have another case here, 25 CR 727, that is scheduled for sentencing this morning. Now, this is a felony 5. That other case is a felony 5. Do you understand I could give you a consecutive sentence on these cases? Do you
Yes,
understand
sir.
that?
I do.
If I give you a consecutive sentence, the maximum penalty would be 24 months in prison and a $5,000 fine. Do you understand that?
Yes, Your Honor.
Are you presently on post-release control to the parole authority?
No, sir.
Do you understand that your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes, sir.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
You understand if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the adult parole authority.
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Your Honor.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
I do, Your Honor.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 24 months, 12 on this and 12 on the other case. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
Have you had enough time to talk to Mr. Fatika before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, Your Honor.
All right, Ms. Contour, if this case went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would have shown that on April 27th of 2025 in Lake County, Ohio, there was a warrant out for the defendant's arrest. Upon being arrested, his person was searched. There was a syringe found in his front pant pocket that was sent to the Lake County Crime Lab and determined to contain methamphetamine, the amount being less than the bulk amount.
All right, Mr. Fatika, anything to add to those facts?
No, thank you, Your Honor.
Mr. Morton, did you hear what Ms. Contour said the facts would show if the case went to trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
What is your plea to aggravated possession of drugs, a felony 5?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
All right, Mr. Fatika? Can you have him initial by the, page 2 by the Suboxone?
This is what we went over. Because there's a change here, you need to put your initials and the date. It's 2/27. Are we okay to sign, Your Honor?
Yeah.
Initial where you put this.
Mr. Morton, is this your signature on the written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, I did.
Do you want me to accept your written plea of guilty?
Please.
All right, I will accept the written plea of guilty. Defendant was present. Will Mr. Fatika advise of all of his rights being a knowing, intelligent, voluntary waiver? He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of aggravated possession of drugs, a felony 5, and the specification. Mr. Fatika, on this case, is he going to waive his right to a pre-sentence report?
Yes, Your Honor.
All right, so we're ready to go to sentencing on 7/27 and on this case?
Yes, Your Honor.
Go ahead.
Your Honor, I reviewed the PSR and the drug and alcohol evaluation. While acknowledging that Mr. Morton has a fairly extensive criminal history, he does have prior failures on probation. The question then becomes, well, what's different this time? I'd respectfully suggest to the court he has a 9-month-old son. He's engaged. He does have family support. We submitted a letter from both his fiancee and his mother. If he was released after treatment, he would reside with his mother until he had stable housing with his fiancee and son. I think it's telling that a lot of people in Mr. Morton's situation are shooting to get out and get into an IOP. He's not saying that. He's saying, let me stay in, let me do the jail treatment program, let me do a residential treatment program. He understands that he needs help. Without demeaning the seriousness of the crimes, these are both residue cases, dirty needles. I think someone with a less serious record, these would have been handled in municipal court, which Mr. Morton, kind of makes a reference to in the PSR. But for all those reasons, we would ask that you consider community control here, consider imposing the recommendations contained in the drug and alcohol evaluation.
All right, Mr. Morton, what do you want to tell me before I sentence you?
Your Honor, I'd just like to say that prior to getting arrested, I did start taking the steps, put myself in IOP, and the MAT program. When I was arrested, I was drug tested coming into the county jail. 24 hours in, I passed my drug test. They're completely clean for everything. I don't plan on being on the Suboxone program forever. I plan on getting on the Sublocade shot and doing that 3 times and being done with that. I have a job. I'm in college classes. My son's my life right now, man. I cry almost every day, every night thinking about him. So I just want to get back to him, that's all.
All right, Ms. Contour.
Thank you, Your Honor. The state is recommending prison in this case. The defendant has 3 prior prison numbers from 2014, from 2016 to 2019, which included a firearm specification. He was placed on probation in 2022. He was not successful and was ultimately sent to prison on 2 cases from 2022 to 2023. He was on probation in a municipal court when he committed these offenses, as well as being on bond in 727 when he committed 650. So the state does not feel that he is amenable to community control sanctions and would recommend prison.
Okay, well, your record indicates that you certainly aren't very good on probation. So
I wasn't on bond when I got that case.
none of that matters, okay? I mean, really, you got a lousy record.
Yeah, I understand
You've been a
that.
lousy probationer, and the question is whether you're ever going to get your shit together, okay? So I've considered the pre-sentence report, the support that Mr. Morton received, what he had stated, what counsel has stated. I'm going to, on both cases, I'm going to place you on community control for 4 years. On 727, you're going to serve 123 days in the jail with credit for 63. On 650, to the best of what I can glean here, I'm going to give you 74 days with credit for 14. So you're going to serve 60 more days in jail. The last 30 will be in the jail treatment program, and you're to follow the recommendations made coming out of there. After that, you're going to go to either Lake House or Concord Pines, and in that program, complete that program, follow those recommendations. You're to have no drugs or alcohol, and you'll be screened. You're going to get a mental health evaluation and follow all recommendations. You're to utilize only 1 doctor, 1 dentist, and 1 pharmacy for any prescription medication. If you are prescribed medication, you're to take it only as prescribed. You're going to sign releases so probation can get your records. You're going to complete the decision points program through probation and follow those recommendations. You're going to attend at least 4 AA or NA meetings per week and obtain a sponsor. You ever had a sponsor before?
Yeah, I have one right now, Your Honor.
Okay. You're going to, at the appropriate time, obtain and maintain full employment. You're gonna get a valid driver's license. You know what you have to do to get a driver's license?
Yes, Your Honor.
What do you gotta do?
I need to contact the BMV and I need to start a payment plan and make a payment towards the license block that I have.
Who's got you blocked?
I believe Lake County.
Well, one of the municipal courts?
Yes, sir.
Which one?
I want to say Painesville, I believe.
All right. And you're gonna pay the cost of supervision fee, so the exception of the jail, all the terms are the same on both cases. You understand all the terms?
Yes, Your Honor.
You have any question about any of the terms?
No, sir.
Okay. Well, you know what happens if you violate, right?
Yeah, I do.
Okay, if you violate, and I find you violated, 24 months in prison.
Yes, sir.
Anything else, Ms. Contour?
Your Honor, items forfeited and bond released.
Yes.
Thank you.
Anything else, Mr. Fatika?
No, thank you very much, Your Honor.
Okay, Mr. Morton,
Thank you,
decide how you want to live, okay?
Yes, sir.
Good morning once again, everybody. Happy Super Friday. Welcome to TCF Live. Why Super Friday? Because anybody can have a regular Friday. We strive for more here at TCF. Couple new faces in the chat. Good morning to you guys. Welcome. You've stumbled into one of the friendliest and most interesting communities in LawTube. This is just a great group, so I think you'll like it here. We're going to stay in the building, but we'll go over to Judge Collada's court.
Your Honor, we're here this morning in the state of Ohio versus Susan Clark, case number 25 CR 1431. The defendant is present in open court through attorney Mr. Patika. On February 17th of this year, the defendant was found guilty by a jury of count 1, possession of heroin, a felony of the 5th degree, count 2, possession of cocaine, a felony of the 5th degree, count 3, illegal conveyance of drugs of abuse onto the grounds of a specified government facility, a felony of the 3rd degree, and count renumbered for trial as count 4, possession of a fentanyl-related compound, a felony of the 5th degree. We are here today for the purposes of sentencing.
Thank you. Mr. Fatigue, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, thank you. I've reviewed my notes from the PSR on 25 CR 320. I'd like to highlight the fact that Ms. Clark is 44 years old. We understand she's under sentence on the prior case. Seeing the video from the current case really drives home the fact that she was in a bad way, is in desperate need of help. My hope for her is that at some point at the conclusion of her sentence, she gets the help she needs and turn things around. Again, she's 44 years old. We'd ask the court to consider, she's already serving a year and a half, we'd ask the court to consider either concurrent term or a consecutive sentence at the lower end. Thank you.
Ms. Clark, you have a right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yeah, I wrote a letter. Okay. Morning, Your Honor.
Morning.
Oh, this is kind of hard. Okay, so I wrote, once again, we sit here and, here we are. I just don't even know how to convince you that I'm a person that deserves a chance. Before you sentence me, I just want you to understand what made me the way I am today. This is not easy to say out loud, but I feel it's necessary. When I was 3, my stepbrother took my innocence on more than one occasion. My mom failed to protect me. Then when I was in the 8th grade, my stepfather, who was very creepy but never did what his son did to me, was accused of molesting my cousin. That's when my mom finally divorced him. But the damage was done. I was in downward spiral, drugs, alcohol, self-mutilation, promiscuity. I was looking for something to fill the void and the hurt. I'm guilty of making poor choices. I'm my own worst enemy, but I'm a good person. I fought my hardest in this case to prove that I did not convey drugs into the jail. I thought they were already confiscated from me. There's no way I could have known that they were underneath my EKG sticker. I also want to tell you that I lost my daughter Justine to foster care last time I was in prison, and her dad was sick and in a nursing home. She was just finally able to come home last month, and I failed her once again by choosing drugs. I also have a 24-year-old daughter, Emma, who has struggled with my drug use and being in and out of jail. She recently just forgave me as well. I've been incarcerated for 6 months now. I still have a year left. Please know that I'm a worthwhile person that deserves another shot. I'm not making excuses. I hold myself accountable. I absolutely broke the law. I deserve to be punished, but I also deserve to be seen as something other than a criminal and an addict. I'm a survivor. I'm a mother. I'm a friend. I have a heart. I mean well. I once again apologize. Just please have compassion and leniency. My kids need their mom clean, strong, and healthy, but also home. If you decide to give me multiple years on this sentence, can you at least make it possible that I get drug and alcohol treatment, or maybe run it concurrent, or able to get a judicial or parole or GC? I just find it in your heart to help me and do what's right and fair. Prison is a really tough / sometimes violent place, and I'm scared. That's all, Your Honor.
Thank you.
Thank you.
Take anything else?
No, thank you, Your Honor.
Ms. Contour.
Thank you, Your Honor. The state is recommending prison in this case. Ms. Clark was sent to prison, first given probation and then sent to prison in 2023. She's currently serving a sentence for the exact same offenses, legal conveyance and possession of drugs. She committed these offenses. Well, there was a warrant out for her arrest in one case. She committed the other. We believe that prison in consecutive time is appropriate in this case.
You know, Ms. Clark, everything that you just said in that letter you read, I've heard before from you. You say it every time you come to court, and then you don't get help. And you've been given help by the court before. It hasn't that we just washed our hands with you from the very beginning. You were given treatment. You were given help. You had jail treatment. You had NeoCap. You had Hitchcock Center. And you don't take advantage of it. The safest place for you is being locked up. You haven't been with your family and kids for years. That doesn't motivate you. If that doesn't motivate you, I don't know what would motivate you. You've been saying the same stuff about your kids and children and wanting to be there for them and be together for years, and you don't change. So that doesn't do anything for you. And if that doesn't, I don't know what would. And you don't accept responsibility. I don't know how you think the bags of the drugs got underneath the sticker, the tape. The nurses put it there. They put it there and left it there so you can bring it into jail. You know exactly what happened here. Police didn't find it on you, and you knew you still had it. You knew you were going to jail, and you knew how you were going to feel once you went to jail, and you didn't want to feel that way. And you brought that in with you to help you, prevent you from feeling that way. Or just to get high. But I mean, the only other explanation is that doctors or nurses stuck it underneath the tape. Does that make any sense? I've considered the facts and circumstances of this offense. I reconsidered the prior PSR that was done. Consider what's been said here in court by the defendant, her lawyer, the prosecutor. All this is considered by the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, factors indicating it's more serious. I mean, the defendant overdosed here. She had to be brought back to life by the police as a result of possessing these drugs. So these for counts 1, 2, and 5, renumbered as 4 for trial. Makes it more serious. Nothing makes it less serious. So recidivism factors. She had a pending charge in this case, in this court, excuse me, for, warrant was issued because she failed to appear for her sentencing, I believe it was, at the time she committed this offense. She had done another case in front of this court. She didn't appear, a warrant was issued. She absconded from the area, went down to Columbus for a while, came back and used drugs and overdosed. And that's when she committed this offense with that case pending while awaiting sentencing. She has a lengthy criminal history. Goes back over 25 years. She has failed in the past to comply with previously imposed sanctions ordered by courts. She's been put on probation before. She's been given chances. She's been ordered to go to treatment. And she every single time is violated. This court has given her opportunities before treatment. She's violated. No genuine remorse in regards to, I mean, she admits to the possession charges. I don't want to get the record confused on that aspect, but in regards to the felony of the third degree, there's no genuine remorse. She completely denies it, which she can do, but her denial just defies common sense. Those are all factors indicating recidivism is just basically guaranteed here. It's just going to continue. You don't have to be ordered to get treatment. You can go get treatment on your own. But you don't do that. No factors indicate recidivism is less likely. Under 29-29, what would it be, 13B1, defendant has previously served a prison sentence. She was currently serving a prison sentence as well for the other case, 25 CR 1431, which she was sentenced to. Prison is consistent with the purposes and principles of sentencing. Therefore, it'll be the sentence of this court. Then in counts 1, 2, and 5, renumbered as 4 for purposes of trial. Defendant served a term in prison of 11 months. On count 3, it's ordered the court defendant serve a term in prison of 18 months. Those are all run concurrent to each other. The prison term in this case will be served consecutive to the prison sentence. This case is 1431. I think I misstated that before. But this case will run consecutive to the prison term imposed in 25 CR 320. There's no credit in this case, as she's been getting credit on the other case this entire time. Need to advise you upon your release, you may be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court further finds consecutive service is necessary to protect the public from future crime. To punish the offender, consecutive sentences are not disproportionate to the seriousness of her conduct and the danger she poses to the public, and that she committed these offenses while she was awaiting sentencing. Her history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. Lastly, I need to advise you that you do have the right to appeal the conviction in this case. Specifically, if you are unable to pay for the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain an attorney for an appeal, counsel will be appointed for you without cost to do that. Further, if you're unable to pay for the cost of documents necessary for an appeal, which would include a transcript of the entire proceedings of the trial and any time we are here in court, the documents and the transcripts will be provided for you without cost. And you have the right to have a notice of appeal timely filed on your behalf. And I'm assuming we're going to want to probably appoint someone in this particular matter for an appeal based on the issues that have been brought up.
Please, Your Honor.
All right, the court will appoint an attorney to represent you on your appeal.
Thank you. This is another 18 months.
Ms. Conter, is there anything else for the record?
Your Honor, the only thing that did not go to the jury were the forfeiture specifications.
Oh, yeah, I'll forfeit the contraband and instrumentalities, all of your paraphernalia.
Not for the jury.
Thank you for that. Mr. Fatigue, anything else?
No, thank you, Your Honor. In the past, you've asked me to keep track.
Yeah, and just make sure the notice of appeal gets filed. I appreciate that. I mean, hopefully we'll get someone appointed here quickly, but if you just don't mind monitoring that, make sure that right of hers is protected.
Thank you.
Appreciate
Alrighty, friends, TCF Live on a Super Friday. Nice to have you all here. I've got my eyes on multiple courtrooms out in Courtlandia this morning, but it's weird, as it normally is on a Friday. Judge Mercer's having tech difficulties. Go figure. That seems to be the Jackson County norm right now. Many courts are muted. Apparently, judges have forgotten about hitting or not hitting the mute button, whichever direction it goes. So, and we're doing our standard Friday trying to dodge landlord-tenant as much as possible. But there is stuff going on in Lake County. So let's go back to Judge O'Donnell, new contestant.
In regards to sentencing, there is no agreement, but there is mandatory time on count 2.
Mr. Mulkey?
Thank you, Your Honor. After multiple conferences with my client as well as the state and thorough review of the plea paperwork and evidence with my client, I believe he desires to enter a plea as stated by the state here this morning.
All right, is that correct, Mr. Mackey?
Yes, sir.
All right, how old are you?
41,
How far did you go through school?
graduated.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
You ever been diagnosed with or treated for any mental illness?
No.
All right, now before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand the question, then stop me. If you want to talk to Mr. Mulkey some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to count two?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, sir.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
Now, count two, operating a vehicle under the influence of alcohol, drugs, or a combination is a felony of the third degree. It carries a maximum prison sentence of 60 months and a maximum fine. Is that the maximum, or that's just the mandatory?
The mandatory is the 1,540.
So max is 55?
The max is
5,000?
10,500.
Okay. So the maximum fine would be $10,000. Do you understand that?
Yes.
10,500. Do you understand that?
Yes.
Okay. Now, with regard to this, the sentence on this case, there's a mandatory sentence of at least 120 days in prison. Do you understand that?
Yes.
And with regard to the fine, it's mandatory, and the minimum amount would be $1,540. Do you understand that?
Yes.
All right. Now, after your mandatory, say for instance, I gave you a mandatory prison term of 120 days, I could then place you on community control for up to 5 years. Do you understand that?
Yes.
And if I did that and you violated any conditions, I could send you to prison for up to 60 months. Do you understand that?
Yes.
Or I could just give you a sentence of 60 months. Do you understand that?
Yes.
Okay, so you've got to do at least 120 days, but you can do up to 60 months. You understand that?
Yes, sir.
Any questions about that?
No.
All right, there's also a mandatory, you would have to engage in a mandatory drug and alcohol addiction program. Do you understand that?
Yeah.
There's also a mandatory driver's license suspension of at least 3 years up to a permanent revocation of your license. Do you understand that?
Yes.
And there's a mandatory forfeiture of the vehicle used at the time of the offense if it is registered to you. Do you understand that?
Yes.
Okay. Any other penalties I missed here, Ms. Alessi?
No, Your Honor, that does cover it. However, I did realize there's a mistake on page 2 of the written plea of guilty under the first chart. I have the revised code section for count 2 as A1A. It should be A2. But you did cover all the penalties.
A1, A,
It should just be A2.
A2, okay. All right. Now, Mr. Mackey, if a prison term is imposed in this case beyond the 120 days, then upon your release, You might be placed on post-release control for up to 2 years under the parole authority. Do you understand that?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority can send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If the violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
If I impose a prison term beyond the 120 mandatory days, you would be eligible for judicial release after that mandatory time. Do you understand that?
Yes.
Now, as I said, after that mandatory term of prison of 120, I could put you on community control for up to 5 years, but if you violate, I could send you back to prison for up to 60 months. You understand that?
Yes, sir.
All right, now, has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand at the time of sentencing, I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No.
All right, Ms. Alessi, if the case went to trial, what would the evidence show?
The evidence would show that on November 13th, 2025 at 12:09 a.m., Wycliffe officers are working a traffic detail on State Route 2 where they observed a vehicle enter into the construction zone, almost striking the workers. The vehicle was swerving in and out of the lane and continued on State Route 2 eastbound, where the officer then initiated a traffic stop and identified the defendant as the driver and sole occupant of the vehicle. The officer, upon speaking with the defendant, detected an odor of alcohol. His speech was slurred and he was unsteady on his feet once he was asked to exit the vehicle. The defendant refused to submit to standard field sobriety tests and later refused to provide a breath sample. The defendant did acknowledge that he had been drinking on that day. During an inventory of the vehicle, officers located an empty bottle of Sutter Home Pinot Grigio and a receipt from Old World Tavern from about just an hour prior to the incident, where the defendant had purchased 10 drinks. The defendant had previously been convicted of violations of the OVI statute within 20 years of this conduct as outlined in the indictment, including a prior felony violation. Thank you.
Thank you. Mr. Mulkey, anything to add to those facts?
No, Your Honor.
Mr. Mackey, did you hear what Ms. Alessi said, that the facts would show if this case went to a trial?
Yes, sir.
And are those facts true?
Yes.
What is your plea to count 2, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination, a felony 3?
Guilty.
Mr. Mulkey. I changed the code section on there, so you might want to have an initial on page 2.
They just changed the code section. If you can just put your initials next to that one. Almost done. Signature part here. All right, that's good.
I've witnessed the defendant and his attorney sign their plea of guilty. I've signed it as well. May I approach?
Yep. Mr. Mackey, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present when Mr. Mulkey advised of all of his rights in a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, consequences of his guilty plea, and the maximum penalty. Find to be knowing, intelligent, and voluntary. Will accept his plea of guilty and find him guilty of count 2, OVI, a felony of the 3rd degree. I'm going to refer this for a pre-sentence report, and the drug and alcohol evaluation sentencing will be on March 26 at 11 a.m. Anything else, Ms. Alessi?
No, Your Honor, thank you.
Mr. Mulkey?
No, Your Honor, thank you.
All right, we're adjourned.
Okie dokie, friends. So, Great Granny asked earlier if, she said, can an appellate court add more time if an appeal is denied? So, here's your answer. Yes, an appeals court can increase a sentence, although it is not the typical outcome. While appeals courts appeals are usually filed to reduce a sentence, appellate courts may increase one if the original sentence was found to be illegally lenient, below mandatory minimums, or upon a prosecution appeal regarding sentencing. Key details, exceptions to the rule. Although generally sentences are not increased, they can be if the initial sentence did not adhere to legal guidelines. Prosecution appeals. If the state or prosecution appeals a sentence on the grounds that it is too lenient, the appellate court may increase it. Risk involved. If a defendant appeals their sentence, takes the risk that the appellate court may review the case and determine if it should be harsher. Notice of increase. In some jurisdictions, the court may inform the appellant if they are considering increasing the sentence, allowing the defendant to potentially withdraw the appeal. So there's your answer. Yes, it is possible for them to increase the sentence. So, the more you know. All right. Looks like Judge Mercer got his tech issues sorted, so let's go down there for his first appearances.
Process. We have Mr. John McDaniel, Assistant Public Defender at the jail. He is your attorney for today's purposes. In our courtroom, we have Mr. Gill, our prosecutor. I want to make sure you can see and hear him, so I'm going to ask that Mr. Gill introduce himself.
Lawrence Gill on behalf of the state.
Thank you. Is his audio and video working okay, Corporal?
Yes, sir.
Perfect. We have one person that has friends or family here, and that's Erica Smith. Ms. Smith, good morning. Ms. Smith, your husband and your sister are in the courtroom. Ms. Smith, you're here because you've been accused of multiple felonies, ma'am. You've been accused of 2 counts of grand theft, 4 counts of exploitation of a disabled adult, 6 counts of grand theft of a controlled substance, 4 counts of organized scheme to defraud, 2 counts of trafficking in oxycodone, 4 counts of trafficking in hydrocodone, and 2 counts of petty theft. I've read the complaints. There are, I think, about 7 complaints. There is probable cause for these offenses. I'm also aware that you're on probation, but unless counsel corrects me, it looks to me like all of these charges clearly occurred before you were on probation. One of them is a continuing crime, and that's the one of the grand thefts arguably occurs or continues to occur. It's allegedly not returning property that belonged to her employer, but I don't know this is the type of allegation that I would hold her for. I'd certainly consider input from the state. So you got some very serious charges against you, Ms. Smith. I'm gonna listen to the 2 attorneys before I address your bond status. Mr. McDaniel, anything on behalf of Ms. Smith?
Your Honor, we just asked for a reasonable bond.
Thank you, Mr. Gill.
Judge, we'd just be asking for a reasonable bond. We would note that she is on probation. I need to review to see if we are going to file any motion to revoke her bond on a violation, but we'd be asking that she not be able to possess or consume illegal narcotics, that she's able to make bond. And the state has already lodged a Nevia motion to determine source of bail of whatever the court establishes as bond.
Okay, so Ms. Smith, the total allegations include thousands of controlled substance prescription painkillers that you have allegedly taken and they disappeared wherever. That's the accusation. You've not been convicted of anything, ma'am, but you have some very serious charges. You have 6 different first-degree felonies filed against you, or you've been arrested for, and those first-degree felonies all carry minimum mandatory terms of imprisonment if you're convicted.
I did look up some of the weights that are alleged in the complaint, and they would be carrying 25-year minimum mandatory sentences.
They're very serious charges. The reason I'm telling you that is you're going to get very serious bonds because the bonds correspond to the charges. In the grand theft charges, 2 of those, your bonds will be $5,000 each. I'll kind of go slow with these because I know that the jail and our deputy clerk have to write these down. Exploitation of a disabled adult, those are also 3rd-degree felonies. Your bond will be $5,000. There's 4 of those charges. grand theft of controlled substance to be the same bond, $5,000 each. There's 6 of those. Organized scheme to defraud to be the same bond, $5,000 each. There are 4 of those. The trafficking and oxycodone and hydrocodone are the most serious charges you have. Because they're trafficking charges, your bond will be $50,000 each. There are 6 of those. And the petty theft is the misdemeanor. There's $2,500 each. There are 2 of those. If my math is right, your total bond becomes $385,000 cash or surety is your total bond, and you have a condition of random urinalysis on that bond. I'm not going to hold you without bond because it appears to me that the one charge that may have occurred or continue to occur after you were on probation also could have been filed months ago, potentially. So I don't really know that I'm comfortable holding you without bond. The state may ask Judge Garcia to revoke your bond or issue a warning to the VOP. And if they do, she'll review it, and that'll be her call. But I'm not going to do it summarily without your attorney having a chance to look at it closer, as well as Mr. Gill giving him a chance to look at it closer. So the reason the bond is that high is because she's accused of 6 counts of trafficking in drugs. And the allegations are over the course of 4 or 5 years, she allegedly stole thousands of painkiller prescriptions. That's what she's accused of, not convicted. Very serious charges she's accused of. I'm gonna see if your family has any questions. Do y'all have any questions? She can certainly ask for bond reduction. She has to show either that the bond is unreasonable or inability to pay is one factor. And the other factor is things that the judge presiding over the case may be aware of that I'm not aware of today. This is just her initial bond. It's certainly possible. Even if it's reduced, you've got to realize she's got 6 trafficking charges. So if they cut it in half, it's still a large bond because she's got very serious charges. If she's convicted, as Mr. Gill said, there's a mandatory prison sentence for those trafficking cases if she's convicted. Any other questions?
Judge,
You're aware of her condition. She had a kidney transplant. So
I want to make sure she can hear you. So if you'll come on up. Your sister's saying some things and I just don't know that you can hear her. So I want to make sure she can hear you. You can hear her. I'm sorry. Go ahead, please.
she had a kidney transplant, so she has to take anti-rejection medicine every day at 9 o'clock at night. So that's a big factor. She has to stay in a very clean environment, sterile environment. So I don't know.
When was this?
When was the
Kidney
transplant?
transplant,
17 or 8 or 9 years
Well, how was
ago.
she able to pick up patients and take them to doctor's appointments and take them to the pharmacy and stuff like that if she had to stay in a clean and sterile environment all the time? That doesn't make sense to me.
Well, she was the supportive living coach, so
Right.
she didn't live there, stay there with them.
Right, but she took them places and transported them back and forth to places according to the
Right.
complaint.
Well, they're clean. I mean,
But the jail is not any less dirty than the public areas you go into in a pharmacy or a doctor's office.
well,
All
yes,
right.
sir.
So just make the jail aware she does have some specific medical needs, Corporal, and make sure the medical staff's aware of that. That's not going to affect the bond she gets.
Okay, right.
Okay, thank you.
Thank you.
Mr.
Yeah,
McDaniel,
we
you wanted to
just-
say something?
Yeah, we just ask you, take into consideration, that when you set in a bond, that, for the statutes and stuff, it should be a reasonable bond. I know you kind of set it for what the standard is for each charge, but she's got no criminal history before that, that last recent charge, and we just asked that court to consider that, $385,000, she's not going to be able to make. I mean, she's a nurse. She was a nurse before. I mean, that is a awful lot of money, and there should be some kind of reasonable bond that she's able to make. And this is not a crime of violence or anything that I'm aware of. So we just
Yeah.
ask you to take those things into consideration.
She's accused of putting thousands of pills onto the street or somewhere, and I mean thousands, perhaps tens of thousands. If add them together, there are over 10,000 pills that are missing that she allegedly picked up from the pharmacist and did not give to the individual. She's allegedly, you look surprised. So the accusation is you take the individuals, the special needs individuals. I'm telling her family what the accusation is so they'll know. She's accused of taking the special needs individuals that she was in charge of to the doctor, getting a prescription for large amounts of pain medicine over the course of about 4 years, then going to the pharmacy, getting the prescription filled, taking the patient back to the assisted living facility, never logging in any of the pills ever. None of the patients show any pills logged, which is part of her requirements. So the thousands of pills that she picked up from the pharmacy, according to the pharmacist, no one knows what happened to. That's why it's such a serious charge.
So it went on for 4 or 5 years?
Yes, yes. When she got in trouble with the embezzlement stuff, they started doing a closer look at not the embezzlement, the uttering forced instrument thing she's on probation for. They started looking closer at the medical records, and they couldn't find any of these pills. And when they started doing the financial accounting of her clients' monies, there was monthly payments to pharmacies that no one knew what was for. And the complaint alleges that led to what were these expenses for every month, and that led to the missing pills. So that's an accusation. She's not been convicted, but there is evidence of thousands of missing pills that supposedly were put in her possession. That's what she's accused of, okay? So you've got the right to post the bond. I have taken into account everything Mr. McDaniel said, and I'm very concerned about the pills disappearance. That's why the bond is what it is. I wish you the best, ma'am. You'll get to use the phone shortly to try to post the bond. Thank y'all for coming. We do need, I'm not going to hold on to VOP. We do need to give her a notice for a court date, Corporal. When would that be?
4/7.
April 7th at 8:30. Thank you. April 7th at 8:30 will be a court date, ma'am. Yes, sir. That's it for friends or family, Mr. McDaniel, so we can go back to the top of the docket. That's David Albright. Mr. Albright, good morning. Mr. Albright, you're here because you've been accused of one count of driving while licensed, suspended or revoked, sir. There is probable cause in the complaint, Mr. Albright, and I think you're going to be entitled to a bond, but let me listen to the two attorneys and make sure I'm not missing anything. Mr. McDaniel, anything on behalf of Mr. Albright?
No, Your Honor.
Mr. Gill?
Nothing from the state, Your Honor.
Mr. Albright, I'm going to set your bond at $2,500 cash or surety. Sir, you have a condition not to drive a motor vehicle as part of the bond. According to the complaint, you haven't had a license in many, many years. That's the basis for that condition. If you get a license, you certainly can come back to court and ask for permission to drive. And if you get a license, I'm certainly going to consider that. But otherwise, unless that is approved first, no driving. And you have the right to post the bond. You'll get a chance to use the phone in a few minutes, sir. You also will be given a notice for your court date, which will be March the 30th at 9 a.m. will be your notice. Mr. Albright, any questions, sir?
No, sir.
All right, have a good day, sir. Brantley Herman. Mr. Herman, good morning. Mr. Herman, you're here on a no bond warrant out of circuit court for allegedly failing to appear at a pretrial conference. Mr. Herman, the warrant has no bond. It's signed by the circuit judge. You're going to be held until you can get over to circuit court and get this case resolved. Do you have an appointed attorney that Mr. McDaniel's office can notify, or do you have a hired attorney in that case,
They know
or
about
neither?
They got to plead it today. They're pleading it out today. They know about it.
Good deal. Just want to make sure that everybody's on the same page. So right now, you've got no bond. Right now, you've got no bond. Any questions, Mr. Herman?
I signed my plea deal yesterday. Other than that, no, sir.
Good luck.
All right. Wish you the best, sir. I know that Judge Garcia's in a conference, but she may be coming back today. I'm not sure when she's coming back. I talked to her yesterday. She's in a conference. So in his case, we need to give him a notice for the next pretrial date, but his attorney may bring him up earlier than that, Corporal. His will not be an arraignment date. It'll be a pretrial date, and we're going to try to figure out when that is. Mr. Gill, any chance you know?
Pretrial date, next pretrial for public
He's already
defender,
placed on the docket. It's March 10th.
March 10th. That's
Thank you.
correct.
Thank you, Mr. McDaniel. Anything else in that case, Corporal?
No, sir. Thank you.
Yes, sir.
So I don't know. You told me that.
I signed this paper yesterday. My plea deal.
March 10th.
Nicholas Eubanks. Mr. Eubanks, good morning. Mr. Eubanks, you're here for one new charge of petty theft between $100 and $750. Mr. Eubanks, there is probable cause for that offense. And Mr. Eubanks, I'm going to appoint the public defender's officer to represent you, and I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Eubanks at this point in time. He's going to be a no contest. The charge is listed. You understand that he'll be sentenced to 30 days in county jail, $370 fine to serve on any restitution. So
Mr.
That's agreeable to state, Your Honor.
My question is, can we go ahead and get the restitution done so we don't have to deal with it later?
Yeah, I would like
Does it
that.
have an amount in there anywhere? I don't think it does. So the officer didn't,
The total combined value of all stolen items is $118.14.
and then so the next question is, any of it resellable? It doesn't mention recovering any of it in the complaint, does it?
I think they talk about seeing it at
So-
the house.
I think the best we can do is restitution not to exceed.
I would like that.
What amount did you say?
118, 14.
Mr. McDaniel, you okay with restitution not to exceed 118.14?
Yes, Your Honor.
So it may be less than that, Mr. Eubanks. It certainly won't be more than that. Mr. Eubanks, Mr. Gill, first of all, is that agreeable with the state?
It is, Your Honor.
Mr. Eubanks, did you hear that agreement, sir?
Yes, sir.
Mr. Eubanks, is that the plea you would like to enter?
Yes, sir.
Mr. Eubanks, I'm going to accept your plea of no contest to one count of petty theft. Mr. Eubanks, I'm going to judge you guilty of that offense, sentence you to 30 days in jail, give you credit for the 1 day that you've already served, 370 court costs and fines. You can get a chance to work that off at the jail, Mr. Eubanks. Restitution not to exceed 118.14. And Mr. Eubanks, no probation involved. You finish this jail sentence, you're through with this case. Mr. Eubanks, I need to make you aware of something. I'm pretty sure this is your second petty theft conviction. And the reason I want you to know that is under Florida law, if you're charged with this again, it could go to felony court, Mr. Eubanks.
Judge's prior was a withhold, so this would be.
Thank you. Even after the violation, it was a withhold? Withhold, there's a violation of PTI.
Oh, was there a violation? Well, in the court record, it said withhold, so.
And
it
it
is
very
a
well may have
conviction.
been. Your third one is a felony or can be a felony. And I want you to know that. I want you to realize this gets more and more serious, Mr. Eubanks, okay?
I don't recall if it was adjudicated or not, but withhold adjudication is not going to matter on the PCS 3.
No, it does. For
It does?
petty theft, it has to be a conviction. For battery, it doesn't.
It's very confusing because some charges it does matter and some it doesn't. And I always get them
It's petty.
confused.
Battery doesn't, even if with a withhold, it's enhanceable. Petty theft requires 2 prior convictions adjudicated guilty.
Okay. So the bottom line is it becomes a felony at some point, Mr. Eubanks. You need to understand that. You need to, don't be charged with this in the future. Mr. Eubanks, do you have any questions? All right, sir. Wish you the best. We have Arthur Panja. Mr. Panja, good morning. You're here for first appearance accused of 1 count of driving under the influence and 1 count of refusal to submit to a breath alcohol test. Mr. Panja, there is probable cause for the offenses, sir. And my understanding is this is a bond analysis, Mr. McDaniel?
Your Honor, yes, we just asked for a cash bond. I mean, he lives locally, he owns a business locally, he's not going nowhere. He owns a local hotel, so we just asked for a cash bond, let him get out.
Mr. Gill, I normally don't have a problem with the cash bond as long as the state's in agreement. There's a statute that discourages it. But if the state's in agreement, I have no problem with the cash bond.
Judge, I don't have his prior record. Does he have any prior record?
He has one. Well, the record shows nothing in Florida. The record reflects 1 prior arrest in 2021. And sometimes it's hard to find the state. It says Decatur County. I'm going to assume that's Georgia.
Yeah, it's Georgia.
It says false imprisonment, assault causing bodily injury, and
That's
it
not him,
says
Your Honor. That's not him, Your Honor.
deferred judgment. You don't think that's him at all?
I don't
So
think it
there
is,
was
but he's
nothing,
from,
I was going to offer him a conditional release. There was nothing on there that would prevent me from giving the cash bond if you're in
Judge, we
agreement
have
with
no
it.
objection based on that.
All right, so the states are not objecting to a cash bond. I'm going to set your bond at $250 each count. Because 2 misdemeanors, your total cash bond is $500. You do have a condition not to possess or consume alcohol because it's an alcohol-related offense that you're accused of. So, Mr. Panja, you cannot possess or consume alcohol. You post a $500 cash bond, you'll be released immediately. We're also going to give you a notice or ask the jail to give you a notice for your court date, which will be March 30th at 9 a.m. Mr. Panja, do you have any questions?
Not at this time, Judge. Thank you.
All right, sir. Wish you the best. We'll see you March 30th.
Thank you, sir.
Yes, sir. Jessica Salloway. Ms. Salloway, good morning. Ms. Salloway, you're here for first appearance accused of 1 count of driving under the influence. Ms. Salloway, I've read the complaint. In your case, there is probable cause. I've also looked at your criminal history, ma'am. I do not see any prior DUIs. There's some other stuff there that's older, more than 10 years old. I'm going to appoint the public defender's officer to represent you for first appearance purposes. Ms. Salloway, I want to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, at this point, we're just going to ask the court member for a cash bond. She lives locally. She's a occupational therapist here, and and she needs to have her driver's license. So we try to get her to get out and see if she can't go ahead and get signed up for the DUI class, if and whatnot that she needs to get done.
Ms. Salloway, is my understanding that you have no prior DUI charges. Is that accurate, ma'am?
Yes, sir, that's correct.
Mr. Gill, any input on bond or release?
Just that she not be able to possess or consume any alcohol, Your Honor.
And any objection to the cash bond in her case?
Given her criminal history being remote, no objection.
Ms. Salloway, your bond's gonna be the same as Mr. Panja, but you only have one charge, so it'll be $250 cash. Ma'am, you do have a condition not to possess or consume alcohol because it is an alcohol-related charge that you're accused of. So you post the $250, you'll be released. And Mr. McDaniel, sounds like he may have already explained to you the benefits of trying to get your, go through certain steps, possibly since it's the first DUI. Mr. Goodson at the courthouse here is also very familiar with that law. Ma'am, the jail's gonna give you a notice for your court date, which will be March the 30th at 9 a.m. Ms. Salloway, do you have any questions?
No, sir.
Right, ma'am. Wish you the best. Mr. McDaniel, that's everything I had on my first appearance list this morning, unless I missed something. Anything else from the public defender's office?
No, Your Honor.
And Corporal, anything else from the jail?
No, sir.
Mr. Gill from the state?
No, Judge, I did want Mr. McDaniel to know, I did file a nebia motion in this Smith's case. So I know that we didn't touch it today, but I filed a motion.
Okay. All right, thank you. And that's always something the circuit judge will deal with if there's a nebia motion filed.
Yeah.
Thank you.
Whoever-
I'm sorry, Mr. McDaniel. I
I mean,
couldn't hear you,
yeah,
Mr.
just
McDaniel.
let whoever her attorney is on the other case know. I mean, they'll be, whoever it is will be handling all of them.
Okay. Thank you.
All right, ladies and gentlemen, that concludes first appearances for today. It is
All right, that's it for Wade Mercer today. Good morning once again, everybody. Happy Friday to all of you. I hope you're enjoying the show so far. Let's, you know what? Ohio is just kind of where it's at this morning. Let's go back to Judge O'Donnell, new contestant.
Degree, and also to count 3, operating a vehicle under the influence of alcohol or drug of abuse or a combination thereof, a misdemeanor of the first degree as a second-time offense. The state would move for a dismissal of the balance of the indictment. We would ask that the court refer the felony matter to PSR and go forward with sentencing on the OVI today.
Oh, we've got, I mean, we're going to go forward on sentencing on both.
Sentencing
Yeah,
today
that was
and
done.
the, I'm sorry, the intervention on
Yeah, okay.
the felony
Thanks.
charge.
All right, Mr. Kerr?
That does accurately reflect our understanding. At this time, the client would once again move to enter the ILC program and he qualifies under the provisions of RC 2951.041.
All right, based on the information that I have received on the intervention report and the pre-sentence report, I'll grant the intervention motion as to count 2, the improper handling, the felony 4. It's denied as to count 3, the OVI, by the misdemeanor 1. All right. So we'll do a plea on both these charges. All right, Mr. Biddle, how old are you?
33 years old, Your Honor.
How far did you go through school?
All the way through high school, a little bit of college.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
All right, did you get a copy of the indictment in this case?
Yes.
All right. So you are pleading guilty to count, count 2, improper handling of a firearm in a motor vehicle, a felony 4, and count 3, OVI and misdemeanor 1. Is that your understanding?
Yes, sir.
All right. And at the conclusion of the plea, With regard to count 2, the felony, I will state a criminal proceedings and place you on an intervention plan on count 3. At the conclusion, you will be sentenced on that case. Do you understand that?
Yes, sir.
Any questions about how that works?
No, sir.
All right. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Kerr some more, let me know, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you could be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you. Do you understand that right?
Yes.
All right. If you could not afford a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of the transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you do not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
You still want to plead guilty to these charges?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to this felony offense in count 2 that if you are sentenced eventually, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes.
Okay, count 2, improper handling is a felony. Is that a 4? It's a 4, right?
I think it's a
Yes,
5.
right. It's a 5?
It's indicted as a 5.
It's indicted, it is a 5, yes.
Okay. Felony of the 5th degree that carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Count 3, the OVI is a misdemeanor of the 1st degree. It carries a potential, is the second time a year, or is it 180 still?
It's 180 still, Your Honor.
It carries a maximum jail sentence of 180 days, a maximum fine of 1,600. No, that's the mandatory. What's the fine on the second time? You do more of this, Justin.
Yeah, no, they just changed it. I think it's 575, but
That's the mandatory, but the maximum is this is still 1,000, or is it more?
I think it's 1625.
Okay, so the maximum fine on the OVI is $1,625. You understand that?
Yes, sir.
Now there's a mandatory fine. You've got $715 in here.
I have,
$715 on the minimum.
okay.
So it's $575.
Yeah.
If the court could give me
Yeah, go ahead.
Let me look it up.
10 seconds, I'll produce that for you. The range is 525 to 1625.
Okay. At least for this week it is.
I
All
just
right, so
haven't
there's a
updated that.
mandatory fine of at least $525. Do you understand that
Yes,
on the
sir.
OVI? Okay. All right. There is also a mandatory term of jail in this. It's either 10 days in jail, or the alternative is 5 days plus electronically monitoring home arrest. Do you understand that?
Yes, sir.
Okay. Any question about any of the penalties?
No, sir.
All right. Do you understand that on the OVI, there's a mandatory driver's license suspension of at least 1 year up to 7 years?
Yes.
On the weapons charge, if you are convicted on that, you will be prevented from owning or possessing a firearm. Do you understand that?
Yes.
If you get sentenced on the felony and the sentence is prison, then when you are released, you might be on post-release control for up to 2 years under the parole authority. Do you understand that?
Yes.
If you were to be placed on post-release control and violated any conditions, parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation were a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months of the time left under post-release control. Do you understand that?
Yes.
If you were sentenced to prison on the felony, then you are eligible for judicial release. Do you understand that?
Yes.
Or if you were convicted or sentenced, I could sentence you to community control for up to 5 years, but if you violated any conditions, I could send you to prison for 12 months. You understand that?
Yes.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I would sentence you to in this case?
No, sir.
Do you understand that I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk to Mr. Kerr before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No, sir.
All right. Ms. Mulligan, if this case went to trial, what would the evidence show?
Your Honor, the state would be prepared to show that on August 24th, 2025, the defendant was driving in the city of Mentor Lake County, Ohio. He was going the wrong way on State Route 2. He was stopped by the police, and during the course of that stop showed signs of being under the influence of alcohol. The officer noted an odor of alcohol, slurred speech. Defendant refused testing. There was a loaded Glock 27 pistol in the center console of his car that he was the sole occupant of, and that firearm was tested and determined to be operable.
All right, Mr. Kerr, anything to add to those facts?
No, Your Honor.
Okay. Mr. Biddle, did you hear what Ms. Mulligan said? The facts would show if the case went to trial.
Yes.
Are those facts true?
Yes.
All right, what is your plea to count 2, improper handling a felony of the 5th degree?
Guilty, Your Honor.
And what is your plea to count 3, OVI and misdemeanor of the 1st degree?
Guilty, Your Honor.
All right, Mr. Kerr. I'd have to sign him when he's ready.
Your Honor, the defendant has signed the written plea of guilty on his signature and witnessed by counsel.
Thank you. Mr. Mr. Biddle, is this your signature on this written plea of guilty?
Yes, sir.
And did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present. Mr. Kerr advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty to count 2, improper handling of firearm in a motor vehicle, a felony 5. I will accept his guilty plea to count 3 and find him guilty of OVI and misdemeanor 1. On the intervention plan, I'm going to place you on a 2-year intervention plan. On the felony, and the terms are you to have no drugs or alcohol, and you'll be screened. You to obtain a separate drug and alcohol evaluation, follow all recommendations. You're going to undergo a mental health evaluation, follow all recommendations, attend at least 2 AA meetings per week, maintain full employment. You're going to be suspended on the OVI, your license, so you're going to obtain a valid driver's license. And you're going to pay the cost and supervision fees. Anything else with regard to the intervention plan, Ms. Randallson? Do you understand the terms of the plan?
Yes.
Any question about the terms of the plan?
No, sir.
If you violate the terms of the plan, the state will file a motion to terminate your intervention plan. If I find you violated, you face 12 months in prison. You get convicted and then face 12 months in prison. You understand that?
Yes, sir.
Any questions about that?
No, sir.
All right. On the OVI, I'm going to sentence you to either 10 days in jail or 5 days in jail plus 18 days of electronically monitored home arrest. I'm going to impose a fine of, mandatory fine of $525 and a driver's license suspension of 1 year.
Your Honor, would the court consider backdating that to the date of the offense?
I'm looking for the date of the offense. Was it August 25?
24.
August 24? So it's effective August 24 of 2025.
Thank you, Your Honor.
Any other penalties that I missed on that, Ms. Mulligan, on the OVI?
I'm sorry, I'm just having a very hard time hearing you.
Any other penalties that I missed? Any of these mandatory?
I don't think so,
Okay.
thank you.
All right, you understand what the sentence is on the OVI?
Yes, sir.
Okay. Do you know if you want to do the 10 days or the 5 and 18?
I take the 5 and 18, Your Honor.
What are your work days, your normal work days?
I work Monday through Friday.
What hours?
6, so I work 2 jobs. I work 6 a.m. to 2:30 p.m. Monday through Friday. And then my second job, I work Wednesday through Friday from 3 to 10 p.m.
Okay. Do you have a suggestion, Mr. Kerr, as to when? I'm going to give him time a future date to report for those 5 days. Do you have a sense of sometime in March when that would be? Like the 3rd week of March or so?
Yeah, so could he report on a Saturday morning? Would that make the most sense? Probably.
That's fine.
Because, yeah, perhaps March 21st?
All right, you're to report to the Lake County Jail on March 21 at 9 a.m. And then you will then have five days straight, then you will be put on the home arrest, and for the purposes of the home arrest, you will be permitted to work your normal work hours, but that's it.
Yes, sir.
Otherwise, you're right back home. You understand that?
Yes, sir.
All right. If you violate the provisions of that home arrest, then you're looking at 180 days in jail. You understand that?
Yes, sir.
All right. On the OVI, I'm also going to put them on probation for a period of 6 months. Okay. Got that, Kim?
Yes, Your Honor.
Okay. All right, anything else, Ms. Mulligan, with regard, and I talked about this before, what I would like you to do as far as a judgment entry is do two, same case number, two judgment entries, one with regard to the intervention on a felony, one with regard to the OVI.
All right,
Okay.
thank you.
Anything beyond that?
I don't believe so.
Kerr, anything else?
Nothing further, Your Honor.
Okay, you got Mr. Biddle. You don't have much in the past, but this alcohol stuff is causing you all kinds of problems, causing people on Route 2 all kinds of problems. So get it under control and do what you're supposed to do.
Yes, sir, I understand.
All right.
Okie dokie, friends. Let's go down to Texas. Say good morning to Judge Stevens in Jefferson County.
On probation for 13, it's really down to money now. Okay. It was originally 20,157.
Yes, Your Honor.
And now we've got 14.
He's currently at a balance of 4504.
I'm sorry, say it again.
He's currently at $4,504 balance for his restitution.
Okay. Well, what happened was, look, from the time this was filed a couple of years ago, it's like you paid about $10,000 on in the last few years, last couple of years. That's good. So 4,504. There'll be some form of celebration when this is all over.
I know it, I'm ready.
But where are we right now? Are you going to be able to continue to keep up these payments that you've done relatively well in the last few years?
Yeah.
About how much do you have a steady stream per month you're able to pay on this restitution? That's an amount of something?
I don't understand the question.
How much do you pay a month for the restitution?
300.
300. Okay, that's what I was curious about. Okay. So that's 3,600 in a year, and you've got the balance of 45. So that's 3 more months after a year and 3 and 15 months at this rate or sooner. Because all things being the same, he pays this off. Then you send me not just a termination, but a dismissal of this case. It's dismissed, so it's not on your record.
That's a big thing, yeah.
Well, it's a big thing for everybody involved, but also the quicker you can pay it back to these people, because we don't include interest for the lost amount. And this has been 13 years that going on 13 years that this is being paid. So it's so much better that somebody can get their money back as soon as possible, because they're out the use of the money during that period of time that it takes to pay it back, because we don't add interest like the federal government does. Maybe we should, but we don't. What else do we do today?
You said it in 6 months or so, check it again.
I was thinking in 6 months. Is that a good idea? Yeah, okay. And we're going to see where it is in 6 months, okay?
Yes.
Maybe if you didn't pay it off early, once again, the quicker you pay it off, the quicker, all things being the same, this gets dismissed.
I wish I could, Judge.
Do what you can.
All I can do is what I'm doing.
Do what you can.
Very thick skin.
Yes, sir. Do what you can, and then we'll celebrate the completion of this, okay? All right. Thank you very much for your persistence. Yes, sir.
All right, let's head up to Michigan, see what's going on with Judge Elmore.
Mr. Nelson, go ahead and have a seat. We are next taking up the case of People of the State of Michigan versus Robert Nelson Jr. This is file number 26-14199FH. Appearances from counsel, please.
Lisa Dole for the people.
Good morning, Your Honor. Allison Cass on behalf of Mr. Nelson. I believe Lynn Getz might also be in the waiting room.
Pam says yes. Let's welcome her in. Oh. Here we go. And Miss Lynn Getz also joins us from the same defense attorney's office, and Mr. Nelson is here in the courtroom. Now, we are here today for, looks like a probation violation sentencing and a pretrial agreement. Let's go and talk about the pretrial agreement on this new file. Yes, ma'am.
Your Honor, there was a global resolution agreed upon by the parties and proposed to the court. Mr. Nelson would be pleading to use of a controlled substance count 2 in case 2614199FH. We would dismiss count 1, possession of an analog, controlled substance, second or subsequent offense notice, and also habitual 4th. He has previously already pled to the probation violation in case
24-13814F8, which I also call at the same time. Thank you.
Yes, Your Honor.
All right, Miss Castle, I assume you're going to be the one doing the talking today. Is that a complete and accurate statement of the pretrial agreement to resolve file 199?
Yes.
Thank you.
Your Honor, I really apologize for interrupting, but there was one more aspect to the global agreement. It was that the people were not going to file the assault and battery charge. That was pending review. That was one of the probation violation charges. I apologize for not getting that.
Certainly. All right, Mr. Nelson, have you heard what these ladies have told me today?
Yes, Your Honor.
Is that how you wish to resolve this other file?
Yes, Your Honor.
All right, thank you. Please raise your right hand the best that you can. Sir, do you swear or affirm that the information and testimony you will provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Thank you. You may lower your hand. All right, sir. So in this newer file, I understand, and obviously we've already dealt with the fact that you were on probation when it occurred, and we've already dealt with that prior probation violation. So in this file 14199, you are currently charged with a single count of possession of the controlled substance amphetamine, which is an analog, not methamphetamine, but amphetamine. Well, that's a felony punishable by up to 2 years and or up to $2,000. Plus, there are 2 potential sentencing enhancements that could increase those maximum punishments within the discretion of the court if you were found guilty of those. A second or subsequent drug offender enhancement could increase that maximum punishment from up to 2 years to up to 4 years, and from up to $2,000 to up to $4,000. Or in the alternative, you could be sentenced as a 4th habitual felony offender. That would allow the court within its discretion to sentence you up to 15 years instead of 2 years. However, that count, possession of possession of amphetamine, and the 2 enhancements will be dismissed if you enter a plea of guilty to, and I accept that plea, to an added count 2. Added count 2 would be use of that controlled substance, which is a misdemeanor punishable by up to 1 year and or up to $1,000. Is that what you understood you were doing today?
Yes, Your Honor.
Now, entering a plea of guilty to this added count 2 means that you will not have a trial. Does that make sense?
Yes, Your Honor.
If I enter that plea, if I accept that plea, again, you'll be given up these certain rights: the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent, the right to have the prosecutor prove your guilt beyond a reasonable doubt, the right to have the witnesses, the right for you to question and cross-examine any witnesses who appear against you, the right to have the court order any witnesses you need to appear for your defense at the trial, the right to remain silent in the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. You understand those rights?
Yes, Your Honor.
And even more importantly, you understand that by pleading guilty, you'll be waiving those rights and not have a trial in this case?
Yes, Your Honor.
All right. Leading me to believe that I missed one of the rights. Just to my head. Actually, it's The right to be presumed innocent until proven guilty, the right to have the prosecutor prove you're guilty beyond a reasonable doubt. Right to have the witnesses against you appear throughout, the right to question and cross-examine those witnesses. Again, you understand all that?
Yes, Your Honor.
And again, you understand that if you enter a plea of guilty, you'll be forever waiving those rights as they apply to this particular case.
Yes, Your Honor.
Also, you'll be, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right, which is only allowed when you're convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements that we haven't talked about?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, throughout this process, have you been able to speak with Ms. Castles or Ms. Getz?
Yes.
Have they answered all your questions?
Yes, sir.
Are you satisfied with their advice?
Yes, sir.
And do you believe that this plea is in your best interest today?
Yes.
Has anyone made any promises to you as to exactly what the sentence would be in this case?
No, Your Honor.
All right, thank you. Do you still wish to enter the plea as we just discussed?
Yes.
As to added count 2, use of the controlled substance, amphetamines, and analog, how do you plead?
Guilty.
Before the court can accept that plea, I need to have you tell me what you did that makes you guilty of the offense. Back on a certain date, that would be July 1st of last year in the city of Cadillac here in Wexford County. What happened here?
I possessed a backpack that carried some utensils that had this substance.
Okay, and you knew it was there?
Yes, Your Honor.
And did you have in your mind any lawful right to possess that substance?
No, Your Honor.
Did you do it? You already said you knew it was there. And did you use it on or about that date or time?
Yes, Your Honor.
All right, thank you. Ms. Dahl, do you believe the defendant provided a factual basis?
Yes, Your Honor.
Are you aware of any of the promises, threats, or inducements?
I know.
You believe the court so far is in compliance with the court rule 6.302?
Yes, sir.
Ms. Cat, hold on. Ms. Getz, Ms. Castle's doing all the heavy lifting today. Do you agree with all those answers from Ms. Dahl?
Yes, Your Honor.
Great, thank you. If you're gonna have two attorneys, they may well both be involved. So, all right, the court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for that added count 2. Therefore, the defendant is found guilty of that added count 2, and count 1 and the enhancements will be dismissed upon sentencing. My intent here is to likely just sentence with time served as the offense that I just took the plea for, and then move to the sentencing on the probation violation. The only reason I would send it back and do another sentencing date would be if I was going to give them probation. But if I have it run currently, then it's going to be served. So, Ms. Dahl, any objection to that?
No, Your Honor.
Ms. Castle, we'll go back to you. Any objection to this process?
No, Your Honor.
All right, so now we're going to look here at file 13814, and we're looking at this probation violation report, which is also known to us as a CFJ 491. Ms. Dahl, have you taken a look at that report? And if so, do you have any corrections or objections that you think you need to put on the record?
I have reviewed it, Your Honor. I don't have any corrections or objections.
All right, Ms. Dahl, Ms. Castles, have you had a look at it? And if so, do you have any corrections or objections to make?
No, Your Honor.
Thank you. Then let's go to allocution, and we'll turn to the people. Ms. Dahl, the floor is yours.
Your Honor, I'm coming into this case a little bit late. My involvement in this case has been the probation violations. The court is obviously aware of this case from the start. So this time, but based on my review of his conduct on probation, his committing new offenses, him absconding, I don't believe he is a good candidate of probation any longer. He's had multiple violations. His guidelines are 10 to 23. Case, I do believe the court has justification based on his performance on probation to go outside of the guidelines and give him more than that if the court chose to do so. But people are asking that he be sentenced to 23 months in prison because the court has given him chances of probation and given him an opportunity to get help, get treatment, get better, and he has continued to violate the court's orders. So I believe a prison term is appropriate in this case.
Thank you. Ms. Castle.
Thank you. Your Honor, I would like to start by making note of the fact that Mr. Nelson has taken accountability for the mistakes he's made while on probation by entering the plea in this case that he just pled to. He's showing that he is admitting to it and he does firmly want to get better. He is expecting this prison term and he wants to make the most of it. He has plans for programming. I would like to note that he does have credit for 224 days. And based on this, we believe that it should be something within the guidelines, likely at the 18-month mark.
All right, thank you. I should also recognize Mr. Charles Kennard from the Michigan Department of Corrections. That office is the one that prepared the pre-sentence investigation report. Just a quick look. All right, thank you. Mr. Nelson, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say at this time, sir?
Your Honor, I think I have a little bit more than 300 days served.
At 324. Yes, sir.
I would be getting credit for them. And then
if you want,
of course, sir.
All right. Anything else?
No, Your Honor.
All right, thank you. Mr. Nelson. This case originally involved a possession of methamphetamine case, and the court gave you 36 months of probation, 300 days in jail, and then it gave you the opportunities at rehabilitation, and there was an absconder response. This is just that challenge. I spoke yesterday at a drug summit, a rehabilitation summit out at Baker College, and we talked a lot about treatment programs and how many cases involve controlled substances and the opportunities and how difficult it is for people who are struggling with substance use disorder. And so I'm not here to say today that you're a bad person for this offense or even some of the probation violations. It's just a symptom of the disease and how it spreads. At the same time, there's always a discussion about what do judges do. Do they give jail? Do they give probation? Do they give rehab? Do they give prison? And the answer is sometimes it's got to be a prison term because all the other efforts may have failed or they may not have worked. I don't like that word fail. So there are opportunities that were unsuccessful. I'd rather use that word. Failing sounds really negative. And I don't like calling it a problem. Old substances, drug addiction, things like that locally, they are opportunities for people to try to help. People mean the courts, programming, even prosecutors and defense attorneys will often work together to help get a person into a rehab program. It's opportunities for us all to help those who are struggling with that issue. And I know that when somebody is under the influence of a controlled substance or even alcohol, they're not always in control of what they're doing, or at least it impacts them and changes them. So I don't want you to think that I look at this and say, oh my gosh, Mr. Nelson's the evil person here, but you're struggling. I don't know what else to do. We've had a lot of opportunities here, but I hope that you continue to find opportunities. Sometimes prisons, they've got rehab programs, they've got trades, things like that. I know it's not great, but I really want you to know I care. I really hope that someday you come back here to the office and say, hey, Judge, I had one. I need help. Where do I go? I'll tell you where to go. I'll help you get there. And I also hope that you come back and say, hey, Judge, thank you. You don't have to say thank you because no one likes us to be sent to lockup, but I want to see that you come back. You got a lot of life here to live. Sure you're younger than I am. So, all right, anyways, I really hope that you get this figured out. All right, in file ending in 199, the court sentences the defendant as follows: a $50 state minimum fee, a $75 crime victim right fund fee, a $150 court cost, a $150 attorney fee. There's no supervision, therefore there's no supervision fee. I'm not going to assess a fine. And the court sentences the defendant to 38 days with 38 days of credit. The arrest didn't take place or wasn't counted until January 8th. I think it might have been the 16th or whatever. So I'm just giving you credit. That sentence therefore will run concurrent, but in effect it's already been served. The old case. Now, in the older file, the one for which we're here talking about this probation violation, which is file 13814, the court revoked probation unsuccessfully. The court preserves any unpaid fines and costs, and the court sentences the defendant to a prison term that will be 20 to 120 months. And the court, of course, gives the defendant jail for credit, which is 324 days. Now, that only accounts for the days that you've actually sat in jail. It doesn't account for any good time credit, which you get to keep, and that will be added to that amount. All right, so it's not just 324, it'll be higher than that. If you serve 300 days before, for example, it should be a number of days. Anything that I've missed, Ms. Dahl?
Not that I can think of.
How about you, Ms. Castle?
No, Your Honor.
Ms. Getz, how about you? You think I get it all?
You got it all again, Judge. Thank you.
Mr. Kennard, anything that I missed?
No, Your Honor, thank you.
Samantha, do you have an advice and rights form over there? There should be a new one signed by Mr. Off. Or there would be on there to get printed. So, Ms. Castles, Ms. Getz, you were on the monitor here in the courtroom right above Samantha's head. Samantha's new at this job, so if you could all just like look down, kind of like in the Brady Bunch there, see, now they're looking down at you, Sam. You feel the pressure?
Yeah.
All right, ladies, thank you. You don't need to look down. All right, so if we don't get it to you right now, Mr. Nelson, somebody will take care of it, probably somebody from the Department of Corrections. You have the right to appeal your conviction and sentence in this case. That is done by filing a claim of right, an application for leave to appeal because of the original plea and guilty. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you will complete a copy of this document that we are hoping to get to you here today and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Do you have any questions about your rights to appeal?
No, Your Honor.
Do you have any questions about what we have done today?
No, Your Honor.
All right, Mr. Nelson, let's look at this as an opportunity. All right, thank you. We're good.
Have a great morning.
Thank you, Lisa. Nice show. We're good.
Alrighty, folks. There was some discussion in the chat about how long the show should go today because it's, for some people, been dragging a little bit. But the vote is in 4 hours, so that is what we will do. Hi, Ellie. I'll feed you yogurt in just a minute, sweetheart. Texas, back to Judge Stevens.
Okay, I'm you're Gary Metz.
Yes, sir.
And cost number 1624069. And this is financial day. Where are we on this one? He's been on probation for Well, it's going on 10 years.
Yes, sir.
And we had an amount of restitution that was owed. And then where are we?
Yes, sir. He didn't have any restitution. He's had supervision fees. Last year we placed him on inactive. And since
Okay, there is not restitution. It's just, these are just various fees that add up.
Yes, sir.
Court costs, et cetera.
And since then, he made 2 major payments. And so
He had all these fees stopped.
yes, sir.
Okay.
His fees stopped in June.
Okay, good. All right.
And so he made 2 major payments and he paid it down to where he only owes $610 now.
How much?
$610.
And then he pays that, and then what are we gonna do?
Then he'll be done. He actually expires on the 27th of
I'm
next
sorry to hear that, sir.
year. His probation expires.
Oh, his probation expires.
Yes, sir.
Already saying a prayer. When can you pay that? When you, the moment you do, Mr. Menard sends me something and then I sign it and then you're on deferred, right? Or unadjudicated probation? Is that right? Then it gets dismissed, period, in the ball game.
Yes, sir.
All right. When do you think you can do that?
Hopefully by the second week of March, hopefully.
Okay, so we're gonna reset this 3 weeks on a review. Unless we don't need to.
Yes, sir. If he gets it paid off, then I'll send everything over.
Thanks. There you go. You don't need to come back. Otherwise, everything's fine.
Yes, sir.
Good. All right. What do you think? I'm sure you're anxious to get this over with, huh?
Yes, sir.
Let me ask you. I'm not gonna go into the details on this. How's the family situation?
They're good.
Good.
They're good.
That's important. Okay. All right. Well, that's kind of everything.
Yeah.
At the end of the day, especially
Yes, sir.
during holidays.
Yeah.
But every day you find out they're maybe the most important
Yes.
part of your life. And you're a role model there as in the family. So keep it up. Okay.
Yes, sir.
All right, sir. Thank you.
For sure.
I don't think we need another resetting.
No, sir. He should be able to pay that.
Okay.
Tentatively set it.
Just check into it because
And then
I trust he's going to take care of it.
For that, it's easy.
Thank you. Philip Parks.
Stop right there on the end. Yes, sir.
Philip Parks.
Yeah.
Thank you. And we call cause number 17-28417, you and Mr. Parks, correct?
Yes, sir.
You are on regular probation. That means you were found guilty. You were placed on, it looks like deferred initially, then that was revoked. And then you were found guilty, sentenced to regular probation in 2022, 5 years probation. And most from probation, I received a probation review request, so we reset it to today. And it says no MTRP. So from probation, how are things?
Towards his restitution, $500 has been paid since the last time we were here in August.
6 months ago. Half a year. Yeah. Is it all about money now?
Yes, sir. He's on an active probation currently.
Okay. And it looks like this is restitution.
Yes, sir.
And what? What I don't understand is the probable cause affidavit talked about the defendant misdelivering, it looks like concrete and 20 yards delivered. The total amount lost was $1,933.60. However, I'm looking at $33,687. So from the probable cause affidavit, I've got 5,000 cases. Help me refresh my memory. How did we go from 1,000 to 33? Was it discovered upon
I believe so.
more research that there were more deliveries that were misdirected?
I believe so.
What's CO now?
The remaining balance is $31,685.55.
Okay, so the total amount was 33, right? And 687. And this was been on probation since 2018. This is going on 8 years, right? Okay.
Just when we acted on the last MTRP in 22, you placed him on inactive so that he could pay, and at that time you ordered that he pay $200 a month. And
yeah,
so
that'd be 2,400.
And it doesn't seem like
that's not happening.
As to the restitution, I've looked back at the original PSI on this matter, Judge. It looks like when we dealt with this back in 2018, there was in the PSI we had to resolve between $42,000 and $25,000 is what. And it's like looks like it was resolved somewhere in the middle, and that was back in 2018. Just to
okay, the judgment reflects restitution was ordered in the amount of $34,000, a little over $34,000. And he has the amount of it's 31,685 is
The remaining balance.
the remaining balance. So what are we doing about it? Yes, sir.
Well, I just returned back to work this last month. I've been dealing with blindness due to my diabetes. I got one eye left, but I'm pretty sure the 300 that is set up at now, I can still do that as long as I can keep working.
Where you work?
Middleton.
What do you do?
I'm a boiler maker.
How much do you make an hour there?
Say again?
How much do you make an hour there?
26.
Let's see. Are you, it's full time?
Yes, sir.
Okay, so it's $30,000.
Like I said, I ain't been working full time for that.
Okay. So, what other debts do you have other than this?
My rent, my utilities, my lights, my phones.
So how much an hour are you saying?
26. Still got a little challenge with what I'm out, but it's not.
So we always figure it out like 2,000 hours a year.
Okay.
That's what it comes out to on 8 hours, which is $50,000. So you ought to be able to pay more than you're paying at that. So need a financial. Have we done something financially that he signed lately based upon his new income? Let's do that. So. Like I say, you're making 50,000 and
Okay.
You're gonna need to pay more than $300 a month for me to be happy about it.
Okay, well, 500.
Or 30, that's still $6,000. You're making 50. Then that's the minimum. But let me see a copy of what y'all can produce and I'll look at it. But let's do that. Well, for the time being, a minimum of 500 a month. Then we'll review it in about 6 months, see where things are. But we need to whittle this down a lot better than it has been. Okay? Everybody? Whose names? On Billy Willie case, y'all did? I have 3 cases.
Yes, sir.
Where'd he go?
Well, we were just sitting there.
I can stand there. I can stand there. Okay.
You remember Mr. Willie?
Yes, sir.
Yesterday, Sunday, ordered call.
I signed a bunch yesterday.
We just submitted MTRPs, Your Honor. Signed that.
I called in yesterday, but it said on today's start, he turned himself in yesterday.
Come on.
Y'all need to swap places.
Wait, just hang on one second, just didn't say nothing when we finished initial.
Do you need to talk to him before we start or anything?
Y'all need to swap where you're at, sir.
Yeah, we need to stand right.
Anyway, I thought we were going to talk without the client being here for starters. That's what me and Mr. Laird had discussed. But so if I could have a minute, unless.
Sure. You can, yeah, go ahead.
Yeah, okay.
Yes, sir.
Back to the jury.
Judge, I was just want to let you know Mr. Rojas is here.
Go,
I
come
found him
on.
out always. Thank you very much, sir. Mr. Rojas.
Come on up.
All right, Dr. Sir, thank you.
Who's on this? You. Right now, we call 25 CR 1049, the state of Texas versus Christopher Barajas. That's you?
Sure.
You were present with Mr. Marino, your attorney and the state's attorney. As you know, you were charged with this 3rd-degree felony of online solicitation of a minor, which carries with it up to 10 years in prison if convicted. What are we doing today?
Today I'm getting information. There's not been, since I'm so far away that it's not one of my courthouses that I work normally. I don't have a lot of discovery, so I got some today.
Okay.
I'd like to get a little bit of time so I can get some more. Then Ms. Moore and I can talk to her from.
Yes. So Judge, we added him to the discovery portal and I released it to him today. I believe it's some kind of authorization or something he's waiting for it to actually get to him.
Yeah, it's I did all the steps, but it's just pending something. I can't remember, but I can't get into the access.
Okay. Is that, are you working on getting that done though?
Oh, yes, sir.
Yeah,
Yes,
okay.
sir. It's pending right now. And if it doesn't work out, I'll call Ms. Moore and we'll figure it out.
Sounds good.
All right, on bond conditions, did we include a condition about not having access to the internet where according to this probable cause affidavit, all this was happening through websites? Did we do that?
I don't know, Judge.
No, that's going to be done as a condition of your bond. I don't want you shall not go on to any website that certainly is that has explicit materials, sexually related materials, such as the ones it is alleged you accessed.
Judge, can we also make sure there is a condition, we can amend if it's not there, that he have no contact with the listed victim in this case?
I don't want him to have any contact with any child other than his own. And you shall not have any contact with the complainant who is listed in this indictment. Do you understand? Nor anyone on your behalf contact that child. Plus, you don't have contacts with other children other than your own related to any matters that involve the accessing through the internet or accessing in any method for purposes of sexual gratification. I hope that's clear. I'm not sure how I'm supposed to police that. I'm not going to stand over his shoulder and watch him in the internet, but how do we do that?
I'd have to speak with somebody here. I know in Hardin County, Judge, there was a requirement that if they're going to have access to the internet, they had to have it through some type of program that allowed probation.
Do you have to use a computer for any purpose?
No.
Then it's real simple. You will not access a computer for any purpose until we can dispose of this matter somehow. Do you understand? That's the safest thing. I catch you, and that would, your bond, whatever it is, would be revoked, and we would sit it out in jail until we can figure this out.
Yes, sir, I understand.
You have to understand that this is under the law victimization, whether you're doing it in person or through videos.
Yes, sir.
And when it involves children, that is a more serious, it's a form of harmful actions toward children, which we don't want under the law, and this court doesn't allow, and you should know better. Do you have children?
No, sir.
You know?
And Judge, that I'm learning from probation department that there is a program called Remote Com. And so we'll make sure that they explain that to him. I'm sure that's something.
How does that work? Right. Yeah, it's not self-explanatory.
So remote com is like a software that he would install on his device that would monitor any internet use, any calls, emails, phone messages he makes to ensure that he's not using the internet.
All right. Do you use a computer?
No,
You don't have any access to a computer?
I have, well, my wife has a tablet and of course our cell phones. That's it.
So he could download it on he would need to download it on his cell phone, Judge.
You live with your wife?
Yes.
Y'all cohabitate? All right. Well, then, just to be on the safe side, so we have some, how can I police it?
Yes, sir. I understand.
Unless we know it's been done. So talk with the probation office about how that happens. I'm going to order that to be done so that at least the home used computer device, we have some kind of checks and balances to review what you're doing on it, because you're allowed for personal business.
Yes, sir.
but not for criminal activity. Do you understand that? And that's a way of us checking to make sure that we're policing all of this until this can get resolved. What do you want to do next, Mr. Marino, on this? It's 6 months old. What do you do? Are we gonna put it for trial or?
Right now, I'd like to get a reset because I'd like to look at the discovery and everything.
How much time is 2 months good?
Yeah, that's
8 weeks?
that's plenty of time. That's plenty
Okay,
of time.
all right. We'll reset it for 2 months. Also, make sure that you get with your bondsman. Bondsman needs to be told about the requirement. And
I do have one more payment on my bond as well.
Well, and you're taking care of that though. That's between you and the bond.
Yeah,
That's all good.
but the bondsman needs to know about what conditions and this other condition of this software that goes onto your computer, so we can ensure that you're not.
I'm sure there's more send a copy to me. I'll give them to the bonds people. I'll give them to the.
But any time I sense that you're not following the rules in this regard, your bond's going to be pulled. You just sit it out in jail, because this type of offense is harmful to children. All children are potential victims, and they are precious commodities that we're going to ensure safety over. So don't ever even think about pulling a stunt like that again. That's in your best interest. You understand?
Yes, sir.
And here, this is, even the legislature, you don't even have to touch the child. The legislature says you can go to prison for 10 years for doing this. So you can see how strict and important the safety of children are to this court and to the legislation, to everybody. Fix this. This is fixable. Don't do this again, right? Okay. Get a reset. Yes, sir. Right there.
Over here. Thank you, Judge.
Yes, sir. All right, on Wooly. Hey, Joe, just 1 second. Joe, what are you here on?
Jeremy Dixon, Your Honor.
What are we doing on? Let me just look at something here. And then what is this? On Jeremy, I've got a
Jeremy Dixon, we're waiting on the appeal, and I checked and everything's been filed with them, but there has been no ruling on it yet. So we just need to put it off another couple of months. There's an aggravated assault attached to that murder case.
Okay, I've got a supplemental voucher that's, well, I'm gonna call it a voucher, since it's spelled VOOCHER. You use a lot of vowels, but not the right one. But anyway, you've added another fee. What is this about? Help me out. Because it's not real explanatory.
That's from the first trial, Your Honor. That was some medical records that came in and another 12 minutes. Half hour.
It says 1 hour.
Well, that's a little.
But that's what your time sheet says.
Yes.
1 hour.
And some medical.
Okay, is there going to be any more? Or is this it?
There's a big one and there's that little voucher.
Yeah, I just get worried when you send me these bills in an installment fashion. Well, like I'm paying my mortgage. To you. I don't want you to be my landlord. You scare me enough. Glad you'd raise my rent. Oh. Okay, I've signed this, and what else are we gonna need on Jeremy Dixon?
No, so we just need to, we're gonna set it off a little bit so we can check on the appeal. Once that appeal comes through, gets affirmed, then we'll dismiss the aggravated assault.
Just hear the way you put that. What, most of them are. All right, anything else?
No.
Thanks, Joe.
Thank
Okay,
you.
let's go on Mr. Woolley. Mr. Is he?
He's in jail. He turned himself in.
We need him out, right?
Well, in a minute, he wanted to talk first without him, without his client for just a second.
Okay.
Yeah, I had just put him on the docket real quick, because I wanted to try to, move things along. And,
We got 3 motions to revoke probation.
yeah, they're all based on, these things he's got in his hand here. I think that's all he does.
Yeah, so far.
And just tentatively, I kind of wanted to see if we land on it. I wanted to try to work it out today, but I don't know if that's possible based on what we've been talking about.
Thank you.
Oh, just.
Yes, sir. One of them's different because the complainant is different in 2 of the cases.
Timing, this one has to go over here, because it's a more recent. Case. And I've got the allegation of, in 2 of the cases, having contact with the victim inappropriately. And then
It's all based on the same thing. Just one of them, the victim in that case is a former stepdaughter, and the other 2 are with the one that he contacted, Anna Juan.
so, failing to stay off of an unauthorized online computer unless approved. So again, it's communication issues.
And he's got the,
These are the communications, Judge.
when you see what he's.
I'm going to peek and see. There's 2 on that first one, and that Tony Wynn, our victim knows him, that name as a name that he was using when he was living in California, and he was trying to stay away from the police under his name.
Well, there's his likeness, his picture's in the foreground here, so it's hard. He's not part of the communication. Who's the person in the background?
That's the person that sent that. Is a friend of his. They've been friends for a long time.
That when someone made the profile.
Okay.
So I was just curious, assuming all that, his computer hookups and all that, it's not from his email address, so it's some sort of subterfuge. Assuming all that's true, I was just curious where you want to land on it. I want him back out on bond or preferably tremendous conditions somehow.
So that's
I don't want to make a big to do with it and everything.
Sure.
We have the evidence right there. And we've got his history of on probation. I think he's been on about 6 or 8 months.
Yeah.
And I think, I'm pretty sure that he's.
Actually, October 7th.
October, and then just
Yeah, it didn't.
4 for 5 nights.
And then 2.
Well, the first one I think you in April.
Oh, well.
Well, y'all had a trial.
We had an April trial by jury.
Right.
And then 2 subsequent pleas in October. And then these motions, that was October 7th, that he's placed on probation.
Correct.
And these other 2, and then these things. The allegations or inappropriate contact with the victim as of January 16. So that was 2 months. 2 months with, 2 months later, he's doing something that results in motion to revoke probation in each of these cases.
Y'all had your trial, he hired me on the appeal, then I went ahead and appeared on all these other cases, we worked it all out. And then, here we have this thing.
God bless you, I know. Not your fault.
But I have been talking to him a lot, we were actually gonna come down, I was gonna let some time pass, and I was gonna see if you were taking mine off of him, and that's why I've known about his history and probation so far. And then this, he called me, what is today, Friday, I think it was Tuesday. And probation told him that this was going on. So I called them, they didn't call me back. Yesterday I saw the order, so here we are. And I was just hoping we could somehow keep him on probation and let's see where he goes with it.
I'm just gonna say, that's not my inclination. I just, these were all serious matters that were completely made clear to him. The one thing that was more important than anything else was the contacting of victims, which has happened. And it was almost surreptitious, but it didn't take long. Yeah, 2 months. 2 months. He couldn't contain himself within the rules for that. And it was him. They weren't going to him. It was him making the affirmative contact. He knew better. But the problem has been when he decides he wants to do something, it's going to be on his term. That's the experience that I have come to understand that Mr. Worry, the way he acts. And the response on the victim on this, what's the response they've had?
She's the one that called me and reported it to me and to probation. She sent it to me by text message. And she's had doesn't want any contact. She's scared of him. So anything that comes, she's afraid of him.
Am I correct that he's done everything else right on his probation? I think he has.
This is everything.
Well, there was quite a lot of.
I mean, this is,
There's a whole
we're
lot.
talking about
There's a whole lot of community.
victimization here, re-victimization.
I totally get.
Well, these victims have had enough with him on this
Yes, sir.
matter. And they have their voice is heard with me. And we couldn't have made it more clear. Stay away from it. He couldn't do it in 2 months. And people are now hollering, what in the world? How essentially I'm supposed to be fashioning rules to protect them as well as hold him responsible for his behavior.
Right.
And I'm sure their response when they call the district attorney's office is, what the heck? I thought this was clear. I thought the rules were in place. It didn't take 2 months and he stepped out of bounds. He's now re-victimizing me by contacting me. I don't want him. He was ordered not to do that. I don't want him to contact me. And he's still doing it on his terms. The tail's not going to wag the dog in this probation.
Yes, sir. So go loud and clear.
Yes.
So going forward procedurally, you don't want to do a bond, I believe. is
No,
what I'm
sir.
hearing here. And then so
Hearing in about 2 or 3 weeks, 3 weeks.
well, I'm just thinking if
Yeah, I'm gonna set it for a hearing, but if y'all can resolve it, otherwise get it to me and let me police it and see if that's something we can do. But I'm gonna set it. I'm not gonna lollygag on it. We're going to set it when you're ready to be able to be here to represent him and answer these allegations.
Yeah,
But we're moving forward.
Yes, sir.
Yes, sir.
Can I be so imprudent as to ask,
Go on.
do you have, assuming all this is proven, which, do you have any inclinations what you may want to be doing on it or?
Hold on.
And just as the discussion is starting to conclude, he mutes himself. All right. That's dragged on long enough anyways. Before we go to the next topic, the next judge, the next case, the next contestant. If y'all recall, yesterday we watched that really weird trial in Judge Mercer's court where they kept bringing up snakes, rats, and the Lord. I'd like to introduce to you the official Snakes, Rats, and the Lord Jackson County t-shirt. spent a lot of time designing this one yesterday. I think it's one of the best that we've done. So I would encourage you to give that a look. There should be a link for you down below this video. If not, you can go to courtroomfiles.com, and you will find it at the top of the page there. If you are a channel member, remember your 20% discount. That code is listed under your member benefits on the channel. So pick one of these up. It's a really, really cool shirt. Available in 6 different colors, many sizes, and the t-shirt blanks that we use for these are just tremendously good. It's the best out there. We've tried them all. My closet is full of this particular shirt. They are so comfortable to wear. So check it out. Pick one up for yourself and the people that you love. Great for family photos. All right, let's go back to Ohio. Some more Judge O'Donnell.
Left the state of Ohio. Admitted being in North Carolina. You understand that charge?
Yes, Your Honor.
Second violation. Failed to report. You understand that charge?
Yes, Your Honor.
Was there something else?
There is an addendum for a positive marijuana screen.
And a positive marijuana screen. You understand that charge?
Yes, Your Honor.
Mr. Reardon?
Your Honor, my client admits to the violations, and she's ready to proceed to sentencing if the court is.
Is that correct, Ms. Harrell?
Yes, Your Honor.
All right, what's your plea to those violations?
Guilty.
Accept your guilty plea and find you guilty. All right. So, what seems to be the problem here?
At this time, I just want to apologize for my past wrongs. There's no problem at this time.
Well, there is a problem. There's 3 problems. First one, you went to North Carolina without asking anybody for permission to go to North Carolina. Ironically, had you asked permission to go to North Carolina to visit your father, if you had asked Ms. Randazzo that, she would have asked me that, and I would have said okay. Second problem is, after you got back, she told you to report, and you didn't. Third problem is you're smoking pot. So there's a problem. So why do we have these problems?
Well, I've been stopped smoking marijuana. I don't know why it's still in my system.
Well, it was in your system because you were smoking marijuana. And when do you claim you stopped smoking marijuana?
The end of November.
Okay, well, that's not true. If it were true, you wouldn't have tested positive for marijuana.
Maybe the levels can be checked. I haven't smoked marijuana since the end of November. I can guarantee that.
And I can guarantee you that that's not true. Okay, so what are we going to do now?
I can screen every week, but I
right,
have my children all
what
the
about,
time.
why didn't you ask her to go to North Carolina?
My dad, he had an emergency, and I just went. I don't know when he'll pass away, so I don't know when this will be over.
Okay.
And I don't want to be somewhere where I miss that.
Okay, let me try the next one. Why didn't you report the following week when you were told to?
I'm sorry.
Why didn't you report the following week when you were told to?
I don't have childcare.
So how do we go forward with probation if you clearly don't intend to comply?
I do.
Well, you can prove that by actually doing it. So what you're telling me is you're helpless here in being able to do anything that you're required to do to dig yourself out of the hole that you put yourself into.
No, I'm capable of doing that.
Okay, so how are you gonna do it? When are you supposed to report next?
I was told March 9th. March 9th.
Based on being violated, her reporting will now increase to weekly reporting.
Your Honor, as I mentioned in chambers, I have someone here who's going to make sure she reports.
So the only terms I gave you for probation are no drugs or alcohol. Did you get an evaluation yet?
Yes.
And what did they say?
She said it was PTSD and bipolar depression, which she diagnosed me with.
And so what are they doing about that? What are you doing about that?
We meet weekly every Wednesday for an hour.
Okay. So all you have to do essentially is keep doing that, which will better yourself. Quit smoking pot and show up. And otherwise you wouldn't be sitting here in that blue uniform. How long you been in jail now?
Since Monday.
Since Monday, yeah.
Okay. Where are your kids?
They're with their aunt.
Are they better off with their aunt or you?
With me.
Okay. Then why don't you make sure that they're with you? You can't wander through the next 7.5 months of probation with a woe is me attitude, I can't do anything about it, and just continue to float by. You actually have to do something about it to help yourself. Now, apparently you've got others that are willing to help you. So there really is no excuse for any of this stuff. Now, in the next 7.5 months, if you have the occasion where you have to go to North Carolina to see your father, whether it's an emergency or otherwise, then you need to call Ms. Randazzo and tell her exactly what the situation is. They're not out to get you. They're out to provide help for you. Got it?
Yes, Your Honor.
All right, I'm going to continue you on community control, 5 days with credit for 5, and do the little amount I told you had to do.
Yes,
Is she
Your
coming to see you after she gets out today?
Yes, Your Honor.
Go see her after you get out today.
Honor.
Anything else, Mr. Reardon?
Nothing further, Your Honor.
All right, that's it.
All right, it's been a week or two since we've been here. Let's go down to Miami-Dade and see how Mindy Glazer is holding up as we approach the lunch hour there.
Right, so this is February 23rd. They have the incident on video surveillance. Sir, you are ordered to stay away from the alleged victim, Malafe Jean No contact with the victim either directly, indirectly, in person, in writing, by telephone, third parties, and stay at least 500 feet away from the victim, his home, school, and place of employment at all times. Stay away from the 7-Eleven at 2 Northwest 79th Street, Miami, Florida.
Yes, ma'am.
All right, count one's a necessary element. Count two, I'll try to split them. Count one is $1,000 for use of a firearm during a felony. Count two, aggravated assault with a firearm. Actually, I'll split 1 and 5. Count two will be $3,500. Count three, battery. That's for spitting at him. I don't know if he struck him. He spit at him. It doesn't say it actually struck him. Count three is assault. So that one, what did they do? 250 for assault or 150? 150, $150 for count three. Count four, resisting an officer without violence. Probable cause for that charge. $500 bond. Count six, improper exhibition of a weapon is $500. And I'm sorry, count five, improper exhibition of a weapon is $500. Count six, disorderly conduct is $150. You're gonna have to post the bond. Somebody's here for you. I can't promote you because you're not a victim, but you can post the bond and get out of jail. What, 5? Was it $5,800, I believe, is the bond. Do you have money for the bond? Does he have
Yes, Your Honor. He'll be able to.
Yes?
Yes.
Good luck.
I like seeing TV judge. I like your thing.
You know, I was gonna offer you a house arrest if you didn't have money. Sure you got the money?
Huh?
I can give you a house arrest if you don't have money for a bond.
Can you get, I have money for the month. I don't need that. I got trips, man. I can't deal with house. So you pay the month.
All right, just, you gotta be calm. Be calm.
Yeah. My
Okay,
mom
have a good day.
gave me that. Thank you, sir.
And whoever Chuck is, he's gonna post a bond and get out, okay? Next, we have Javier Pacone. Hi, Mr. Pacone. So you were arrested for 1 count of child neglect, possession of cocaine, possession of drug paraphernalia, possession of cannabis. I will appoint the public defender's office for you. There's a small child crying next to an adult male in the bus stop. He's passed out. He was given Narcan.
And then they found drugs on him.
There's probable cause for the charges. I don't know, cocaine, I see cannabis. Where's the cocaine? Was that the first?
It says 2 pipes, one with marijuana, the other one with crack residue.
Sir, you are ordered to stay away from the victim. Was it the child who want supervised? I think it maybe stay away order. That child could have got a hold of whatever you took to pass out, killed the child. You are ordered to stay away from the alleged victim whose initials are XP. No contact with the victim either directly, indirectly, in person, in writing, by telephone, through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, his home and school at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department. Follow report. And I don't know if the child's gonna be placed in TCF or foster care or shelter or with the mother, but if the child's in, is it, you know, if the child's in the house with the mother? Do you live with the child's mother?
My mother. He's with my mother.
Okay. Also, in the event there is an open case in dependency court arising from the same set of facts and events as this case, then any and all orders entered in dependency court regarding your contact, visitation, and custody shall supersede or replace this court's order. Do you want to stay away with? All right, pretrial services alternate bond. Count one is $2,500. Count two, $1,000 for the possession of cocaine. Count three, possession of drug paraphernalia, $500. Count four, possession of cannabis, $1. And that's it. Good luck to you, sir.
The alternate is 2,500.
What? Count one's 2,500, two 1,000, three 500, $4.
Thank you.
With pretrial.
All in all, she's holding up pretty good. Usually she's throwing things by now in her docket, so it's nice to see. For those of you wondering about her audio who haven't seen as much Judge Glazer, so she spent months in an alternate courtroom while they upgraded hers, and this is the result of the upgrade. And they have never been able to get it working well, but what are you going to do? Good news, speaking of crappy audio, Dungeon Court is in session this morning, so we'll be able to go there in the 4th hour. Let's go back to Judge Elmore. He has a new contestant approaching. Let's see what's going on there.
Maybe somebody could take that back and have him sign a copy. So you want 2 copies. One will go back to Mr. Nelson, he'll take it with him. The other one he's gonna put his initials on. Well, that's it right here, you have it. Officer, could you just take one and have him, give one to him, and then he's gotta put his initial. You need a pen, take a pen from, Samantha. All right.
One in there.
Yeah, yep, the gentleman we just had here. All right, now I need an attorney. Good. Our next case here today is People of the State of Michigan versus Levi Evan Spears. This is case number 6-14201 FH. Before the court this morning is Ms. Dean Stark from the Western Misaki Department for Community Corrections. The defendant, Mr. Spears, who's currently in custody, is down here at the defense table. The court also recognizes. Go ahead, tell me who you are.
Nate Carnes on behalf of the people.
Oh my gosh. All right, thank you. And now we're just waiting for Mr. Harrison.
Well, we're waiting for them. Austin, buddy, this is for you. Don't say I don't give my audience what they need.
Lost both attorneys. Samantha, do you do karaoke?
No, I don't.
No? Ms. Stark, do you like to do karaoke? All right, see if we get somebody to sing.
Okay.
All right.
I heard you had good reviews last time you sang
Yeah.
there.
I know I gotta come up with a different song. I like singing a rap song, says if you're, it takes two to make a thing go right. It takes two to make it out of sight. Here he comes, everybody.
I'm sorry.
Jeffrey.
Sorry, Levi. Need to make you wait either.
Jeffrey Douglas Harrison is here in the courtroom, and we're here today for a probation, I'm sorry, an alleged bond violation arraignment here today. Mr. Spears was here earlier this week. That was, I think, a couple days ago, or 2 days ago, on February 25th. For an alleged bond violation. He admitted to that violation had to do with failing to test. The court released the defendant or allowed him to continue or be released on his continued bond, but it ordered him to appear for to appear for testing. And the defendant did appear for testing that day after being released from the Wexford County Jail. He appeared at the Community Corrections Office and allegedly provided a sample and where he tested positive for fentanyl. But he was also found to be possessing a container allegedly with urine on his person, meaning it was either someone else's urine or fake urine. And yes, there's a such thing as fake urine. Mr. Harrison, how does your client wish to respond today?
Wishes to make an admission, Your Honor.
All right. Mr. Spears, please raise your right hand the best you can. Do you swear or affirm the information testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
I do, Your Honor.
You may lower your hand. All right, so Mr. Spears, you do have the right to due process here today, and that is to require the prosecution to put on some evidence to demonstrate that there was a bond violation. That wouldn't be a trial. It could be considered an allegation of contempt for failing to comply with a court order, but we don't do that. We just treat this as a review of pretrial release conditions underneath what's called Michigan Code Law 6.106 paragraph H. However, I'm told today that you're going to admit to testing positive and possessing either fake urine or urine that belonged to somebody else. Is that what's going to happen?
Yes, I'd also like to just apologize to the court and to community corrections for just not being honest in the first place.
Has anybody made any threats or coercion to get you to make this admission today?
No, Your Honor.
So, Mr. Spears, is it true that when you left the jail and you came to community corrections, how long did it take you to get from the jail to community corrections?
While my ride didn't show up, I ended up having to walk. And then I was cold. I ended up going to the store and then calling for a ride up to the courthouse.
What store did you go to?
I ended up at Shell.
The Shell gas station?
Yeah.
The one, is there two?
Across from.
Oh, the Shell gas station is down by the old Cobbs Mitchell building, or the Cobbs Mitchell building or whatever it's called. I got it.
Okay.
All right, and then you got to ride up to the courthouse. Okay, and when you got up there, did you take someone else's urine or a fake urine sample?
It was actually an old sample of my own.
Okay, and
I was just worried.
I got it.
I have been using heavily before I got arrested.
All right.
And I was scared it would still be in my system when I got released.
Yep. All right. And it apparently it tested positive for fentanyl. Is that correct?
Yeah, I had been using heavily before I got arrested in the first place.
All right. The court finds the defendant to have violated the terms and conditions of his bond. His bond requires that he's not to use, possess, or consume any illegal or controlled substance unless provided by through a prescription from a medical provider. You didn't have a prescription for this, correct?
No, I had been struggling with addiction before jail.
I understand. All right, thank you. All right, so now that Mr. And I'll remember from Ms. Stark told us and talked about last time, has there been getting tested before that, correct? That was a yes. Left, right there, Nancy Johnson. All right. Mr. Carnes, what do you think we should do? What's your position?
Your Honor, again, this case involved a defendant stealing a vehicle while intoxicated, certainly by alcohol, possibly other controlled substances, and then crashing that vehicle. So there's a victim out of the vehicle that was totaled, and the community was put in danger, and the defendant is now testing positive and refusing to prior indications. I think a remand is the only option here. I'd ask the court to impose that. Thank you.
Mr. Harrison, your position, sir?
Well, believe it or not, I disagree with that assessment of the situation. These are clearly acts of desperation by someone in the throes of an addictive episode. You know how addiction goes, Judge. You're sober until you're not, right? And that's exactly what happened to Levi. I wish he hadn't connived to attempt to defeat the drug test. He wishes that too. That's part of what he wanted to express to you. Ironically, when they first brought him in, they attempted to test him at the jail and he was unable to provide a sample, so they neglected to test him, released him to community corrections. He had reason to believe there would still be fentanyl in his system. The rest is what he told you. I'm happy to announce as well to the court that most of the conversation I had with Levi this morning was centered around his desire to go to rehab. And we're going to try to find him a spot as quickly as we can. Obviously, if he were released on bond, now that process could be streamlined. We wouldn't have to make a motion for release or modification of his bond to accommodate that. I don't know what else to say. I see this as he recognized he had to stop. He tried to stop. He got arrested in the interim, et cetera, et cetera. This isn't, I hesitate to use this term, this isn't new use, and he has no intention to go back to using. It's just something that happened and the times overlap, and here we are.
All right. All right, thank you. All right, so here we go. I've already heard here from Mr. Spears about what happened. To call something an act of desperation also suggests that there must be a response. Because if someone is desperate and needs help, well, the court needs to find a way to help get them that help. Also, let's not fool around here. The defendant went from the jail, which is that way, about half a mile, past the courthouse, and went to the Shell gas station. By the way, of course, I know the Shell gas station. That way, another half mile or 3/4 of a mile, and then came back here, somewhere between there, and here, this diagonal triangle. I'm sorry, we should start calling it the Westford County Courthouse Triangle, kind of like the Bermuda one. And then somewhere in all that, he got extra urine that he kept. Don't know where he kept it. I doubt he kept it there at the jail. So he must have really gone someplace to either go get old urine or what else is, I don't know. He didn't go straight.
There are text messages in this petition, shows he has people conspiring to get him.
Oh, yeah.
Outside.
Yeah.
Those were attached to the original.
Yeah. Oh my
Better
gosh.
support network.
Yeah. Oh, I even see that on there. Nadia Yates, the person with whom he's texting, had videos or clips of our video. And that's okay. I mean, it's not a big deal. So clearly she knew what was going, and it said, I need clean pee ASAP. Gotta take Levi to courthouse. So apparently he had a ride someplace. But clearly, I'm just gonna say, I think the defendant's lying today. He wants, it's an act of desperation. Yates, if you're watching, shame on you and helping somebody violate a court order. So and Matthew Gray. All right. Good job, people. All right, the court revokes the defendant's bond, remands him for custody of the Wexford County Jail. You can seek to try to get him into a program, Mr. Harrison, but you're going to need to convince me that I do it. I will remember that he and his buddies, his friends, tried to pull one over on the court and community corrections. My likelihood of granting him a bond modification between now and the time this case is resolved, extremely low, almost zero. Thank you. We're adjourned.
Alrighty, friends. So earlier I asked if we should go 3 hours or 4 hours, and the consensus was 4. But I'm going to split the baby on this and do 3.5. And the reason is, to be honest with you, there is just not a lot of quality court out there at the moment. Most everybody is done for the day unless they're doing landlord-tenant or like traffic tickets. And that's not overly compelling. So we're going to go ahead and go to dungeon court now, and we'll run with it until the bottom of the next hour. If you're new here and you're not familiar with dungeon court, this is our guilty pleasure. The Soviet-era Cold War lighting, the screams of the dead from behind the camera, the printer that never stops running, the eternal chair of doom on the right side where no defendant ever seems to sit, even when they're in custody. So I don't know what that chair does there. Old men walking half upright. Justice in Appalachia is best done in a dungeon, in a cold, dank basement. Ladies and gentlemen, I give you dungeon court.
12, 2259 and 10, 627. You have the report. Case compliant. Screens are good. Okay, so that's good, and we're taking care of your fines.
Yes, sir, I have a payment today, $40.
You've already paid, or you're gonna pay it now?
I'm gonna pay it as soon as I get out here.
Okay. All right, I'll put that down. We'll go see the clerk. Does it matter if it's Mondays or Fridays?
No, sir.
March 30th will be your next hearing.
Thank you.
That's a Monday. Go see the clerk.
Yes, sir. Thank you.
You're welcome. Andrew Carr is probably on teleconference. Andrew up there?
He is, Your Honor.
Yes, sir. All right, this is case number 24-7. How are you, Andrew?
I'm doing great, Your Honor. I finished my class for the Foundations for the Trade for the Union. Just waiting to start working there. They're moving us into a family unit today for now. And we just left the hospital to get tubes put in the baby's ears.
Okay, a lot going on. Mr. Tarvin's here from the Counseling Center. I just was handed the report, so looks like things are going well. He's back, are they back in the same unit together?
That's going to happen today, Your Honor.
Okay.
Yep.
Well, that's great. I'm really happy to hear that. Okay, I'm going to keep you coming back. I just want to keep tabs on you. You've got
everything pretty much done, but I want to make sure we're on the right path.
Yes, Your Honor.
So I'm going to go out a couple months this time.
All right, yes, Your Honor.
Let's make it exactly 2 months, April 27th. Okay, good job. We got to stay on course.
All right, thank you, Your Honor.
Okay, thank you.
Thank you, Your Honor.
You're welcome. Jeffrey Collins, he's usually on teleconference. Jeffrey, yeah, he is up there.
Good morning, Your Honor.
Good morning. 191082, 19304, 24, 1521, and you just have to pay on fines. Do you have a payment or have you made a payment?
Yes, sir. It was late this morning. I've been sick, so I'm late, but I didn't even remember I had court till I got my alarm, but it's already been paid. I got you to see it right now, but there's $40 been paid on it.
All right, I'll set you for about a month. Let's see what that's going to be. It'll be exactly a month. March 27th will be your next hearing.
Thank you, Your Honor.
You're welcome. Lance Davis.
Okay. Your Honor, he's also turned in 7 hours of community service.
He's actually done a lot more, but he has 2 community services.
That's
So,
one to the other.
yeah, we made up a plan this morning. He's gonna do this one first and then continue with the other one.
Okay. All right, this is a good report. We can wait, he's got some fines and court costs to pay. We can wait on those till he gets to where he's working.
Your Honor, I am employed right now. I
Oh, okay.
actually plan on making a payment today, so.
All right, very good. How much can you pay today?
50.
Great. Put you down for that. You'll go to the clerk's office and do that. Let's, where are you working now?
The Den in New Boston.
What's that? Is that a restaurant or something?
Yeah.
Okay. Let's make it April 3rd, your next hearing. That's a Friday, April 3rd, first Friday in April. April 3rd, be your next hearing at 9 o'clock. See the clerk to make your payment.
All right, thank you.
Good job. Brittany Endicott. Brittany Endicott. Has not appeared. It's a theft offense and she hasn't done anything on her case. So it'd be a warrant for failure to appear today. Ronnie Gillespie is here, 24601. Community service done, and you've worked extra toward your fines. You're getting close to being finished. And you finished that at Lawrence County Recovery. I got a letter from them. So are you paying anything?
Yes, I got $25 to pay today.
Okay. I'll set your next hearing for April 3rd. Get it done before then. You don't have that much left. You don't have to be here. 9 o'clock, April 3rd.
Thank you, sir.
You're welcome. Stephen Kerman, 22-2038.
Your Honor, I have 2 forms here I'd like you to just take a gander at so you know why I wasn't here on the 20th like I was supposed to be.
Okay. Okay. All right, sorry for the death in your family.
Thank you.
Okay, and I think I'd marked it till today anyway, so, all I'm showing you got left is, 10 hours community service, is that right?
It's close to that, yes.
Okay. Let's get that done, you'll be completed.
Yes, sir.
March 27th will be your next hearing. If you confirm you get that finished with your probation officer, you don't have to be here. March
Yes, sir.
27th, 9 a.m.
27th.
27th.
Thank you, Your Honor.
Exactly.
Thank you.
You're welcome.
Gregory Henry, Levi Jones, Holly Lewis, Michael McKenzie, Eric Romans, Matthew Starcher.
Greg Henry, 25, 320, 322, 25, 322. Gregory Henry.
Yes.
You just have to pay on fines and court costs. Do you have a payment?
Yes, sir.
How much are you paying? You paid on the 25th, didn't you? I see it.
Yeah.
Okay.
I'm gonna try to have another payment in here by the end of this week.
I'll set you, this is your this is your second review, so I'm going to set it for April the 10th. Write that down, April 10. If you get it paid off, by then you don't have to come back.
Okay.
I'm showing a balance of 260.
Yes. Thank you, Your Honor.
You're welcome. Levi Jones, 25, 323. He's at our United Family Recovery. It looks like we had a little pickup to deal with, and things are better now.
Yes, he's turning it around nicely.
Okay. And he has done some community service since last hearing.
I'm gonna try to be here tomorrow. Do we do community service on Saturdays?
We do.
Yes.
I'm gonna try to be here tomorrow and finish that out.
Okay, good. I'll set you for April 6th, that's a Monday. April the 6th.
Thank you, Your Honor.
Holly Lewis,
Thank you, sir.
you're up, 25, 956. Okay, she has done her community service and the response, but she was ordered to OVP, and it looks like she passed on doing that, but she's not here today.
Miranda texted me, Your Honor, and said that she's gonna be running late, she had a meeting today. She didn't give me a report on her, but she did another person.
I'll set it to the side and we'll get a report on Ms. Lewis when Ms. Mint gets here. Michael McKenzie, I did get a report from him. So I think did you get OVP then, or are you going to OVP now? No? Check.
What's OVP?
No, it's a different person. I was confusing you with somebody else. I did get a report on another person with a similar name, but it wasn't you. I'm OVP. Bless you. Okay, it says, I mean, it's been quite a while, it sounds like, and he hasn't engaged in any treatment. Non-compliant court treatment. What say you?
Yes, Your Honor. My dad suffers from Alzheimer's. I'm the only child. I live with my mother and him, and I'm his sole caretaker. I have to lift him. I have to feed him, bathe him, do all of these things. We have some home health from Abbott Healthcare that comes in and does vitals and stuff, but we have no one that's there overnights to be able to.
Does this prohibit you from using the phone? Because it says you didn't even call in and check in with
My
them.
phone was disconnected. I did pay the $300 fine.
Yeah, I see that. Okay, I'm gonna order you to go do a urine screen. I wanna
Okay.
see what that shows.
Okay.
We'll decide what we're gonna do about it. Jared Romans, 23,648. Looks like everything's done, except I'm looking for a dip school.
We are looking for a dip school. Last time me and you had spoke, I'd let you know they had to take my thyroid out due to cancer concerns.
Okay.
We did find out that the cancer did spread into several lymph nodes in my neck. That right there is the treatment that I've been getting. And I think I have one more treatment left. I'll be honest, Judge, it has taken a lot out of me. I'm not able to work right now because I'm on 14 different medications. My medication list is on the very back. It takes a lot out of me. As soon as I get this done and taken care of, I will get my DIP school, but it's just, this
Okay,
is.
I'll give you more time under
Thank
these
you.
circumstances. I won't have you back until 2 months out. So
Okay.
let's go April 27th for your next hearing. And that looks like to me the only thing you need to do to finish things up. Okay, April 27th, 9 a.m. is your next hearing. Good luck.
Thank you, sir.
You're welcome. Matthew Starcher is here, 25, 434, and 435. Is that focus? Doing outpatient now. Compliant with the program. What are you doing? Are you working? What's your plan?
I'm currently trying to get back to work right now, sir. I went and spoke with my former boss, but my tools have gone missing since I've been away. So I had to put in applications elsewhere. I've got a background check that I'm waiting on right now at the Take 5 car wash. That's looking like the best thing so far, but
Okay.
staying at it.
All right, keep working at it, and I want you to continue with the counseling that you're doing outpatient. And I'll set you in April, let's make it April the 13th to be your next hearing. Okay, good report, thank you.
Thank you, Your Honor.
You're welcome. Okay, we're going to start the arraignments now for people that have new charges. If you've got a new charge, your name's going to be called. So let's get anybody in here in the courtroom that has.
Arraignments, if you're accepting arraignments, you do court now, arraignments.
When your name is called, come up to the table to your right. I'm going to go over the charges with you. You have the right to remain silent. You don't have to say anything. If you do make statements, though, it's on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, to make the state of Ohio prove the charges against you beyond a reasonable doubt. If you enter guilty or no contest, you're waiving those rights. You should not waive your rights if you don't understand what's happening, if you're confused, if you don't know what to do. Not guilty should be the plea you enter, or if you want a trial or you want to talk to a lawyer, not guilty is the plea. That's the safest plea because it preserves the rights you have. Call the first case.
State of Ohio versus Terry Ray Snyder, case number TRC 26310, A and B.
Mr. McNally, please.
Good morning, Your Honor.
Do you wish me to read the charge?
No, Your Honor, we'd waive.
Not guilty plea entered. Do you have a preference as to the pretrial date?
March 9th, if we could, Your Honor.
That should be okay. Let me check it. Yes, March 9th for pretrial. 10 o'clock, not guilty plea is entered. He will need to get fingerprinted at the jail.
Okay.
We're a little short-handed today because Mr. Cooper is not here. I need him to sign an OR bond. Yeah, that form. And then that's the form we'll have to take to jail to turn in. Next hearing is March 9th, 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jordan Douglas Miller, case number TRC 26313.
Sir, you Jordan Douglas Miller.
Yes, sir.
Mr. Miller, the state's alleging that on February 21st at 7:35 p.m. in Perry Township, you were driving a vehicle while you were under the influence of either alcohol, drugs, or some combination of those substances. The state's alleging this, if you get convicted, it would be your first offense. So on a first offense, the maximum you face is 6 months in jail, $1,075 fine, 3-year driver's license suspension. That's the most that can happen if you're convicted. There is a minimum. The least you can get if you're convicted is 3 days in a treatment program, $375 fine, and a 6-month license suspension. Do you understand that charge and possible penalty?
Yes, sir.
State's alleging that you submitted to a urine screen. Those are packaged and sent to the lab in Columbus for testing, and it takes quite a while, several weeks to get the results. I don't have any results today. All right, with that said, how do you wish to plead to the charge that you were operating a vehicle intoxicated?
Not guilty, Your Honor.
Do you wish to be considered for a court-appointed lawyer?
Not at the moment, no.
Okay. It's going to take 9 weeks at least probably to get the results back. So I'm not going to set a hearing for you for about 9 weeks.
Okay.
You could wait and see what the results are, or you can go hire an attorney today if you want to. It's up to you. You can hire one on your own. So let's see, about 9 weeks would be wow, May 1st. So I'm going to set your next hearing for May 1st. That's a Friday. Pre-trial at 10 o'clock. Mr. Miller can sign a signature bond, and you will have to go to the jail and get fingerprinted.
Okay.
And Mr. Major's going to give you the form to take there. If you want to stay at the jail, but you got to go in there and get fingerprinted. I'm letting you sign a signature bond, which just means you are promising that you'll come to court or you'll pay a $1,000 penalty for not showing up, and you get a warrant for not showing up. So
Yes,
you
sir.
come to court, you won't have to post any money, and do go get the fingerprint. So I take it that you may hire an attorney, is what you're telling me, correct?
Yes, sir.
Okay. Any questions that you have? There is no license suspension as of yet, because you don't have, if you take a test and test over the limit, then it's an automatic license suspension, but there's no automatic license suspension under this scenario with the urine test.
Okay. The one question that I do have, you said 3 days in the treatment program. Is that overnight, 3 days?
It is.
Okay. Okay.
And that's mandatory. The legislature says that. That's what they say you have to do, or 3 days in an overnight program or three nights in jail would be the equivalent. So
Okay.
most people don't want to go to jail. So.
No, sir.
Okay, any other questions?
No, sir.
Okay. May 1st will be your next hearing at 10 o'clock.
Okay.
And Mr. Major will come out and bring you the form.
You just want to have a seat out there, I'll bring that form out to you.
Yes, sir.
State of Ohio versus Justin Bruton, case number CRV 2662.
Sir, Justin Bruni.
Yes, sir.
Mr. Bruni, you're being handed a copy of the charge. It's an assault charge, and it alleges that Perry Township, January the 16th of this year, he knowingly caused or tried to cause physical harm to Megan Swain. If that's spelled correctly, but it's S-W-A-I-N. So that charge is assault. It's a first-degree misdemeanor, carries a maximum penalty of 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir, I do.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
I think so.
Are you working?
Yes, sir.
What do you do?
Lead carpenter for solid rock construction. I do exteriors, soffit and hardy siding.
Are you working full-time?
Yes, sir. I'm supposed to be here right now.
Okay. I have to determine what your gross annual income is. Do you file an income tax return?
Yes, sir.
Okay, do you know what your gross income is?
Like 27.
Do you have dependents? Do you have any children or anyone that you have to support?
Just a bunch of bills, sir. That's it.
Okay. You're a single person?
Yes, sir.
Okay. Well, you're actually over what I can appoint a lawyer for. So if you want a lawyer, you're welcome to it, but you have to hire your own. I can't appoint one for you. So, probably need some time to get that done.
Yes, sir.
Is there a protection order question on that?
Yes, Your Honor.
Okay. Is there any problem with you staying away from Megan Swain?
No, sir. I think she's just in the wind up. I don't even know that she lives in this area anymore.
Okay, well, that should make it, you don't live together or anything like that?
No, sir. We haven't been together. No, sir.
Well, my main concern is that nobody comes, and you should be concerned about it too. We don't want you to be alleged to have done anything else to her. I don't know that it's true or not, but I just don't want there to be a problem. So I'm going to order you stay away from her.
Yes, sir.
And you're telling me that's not a problem?
Not a
You don't
problem.
live together.
No, sir.
You're going to sign something that says, I promise to stay away from Megan, I won't go around her, I won't contact her. And here's another I have to say, nowadays, don't post anything about her on social media.
Oh, yes, sir.
Okay?
Yeah. I'll give you a copy.
Okay, so I'm going to have to set another hearing. It's going to be either a Monday or a Friday. Which is better for your work schedule? Doesn't matter.
Friday's fine.
Fridays are better. A month, you need a month to get a lawyer?
Yes, sir.
Okay, that's March the 27th now. That's when I set your next hearing.
Yes, sir.
March 27th. You want to write that down, there's a little form there in that basket to put your next hearing date on. March 27th, it will be a pre-trial at 10 a.m. Visitor protection order, and you can get a copy of the prosecutor if you want to stick around. They'll bring you a copy of that. Take it to your lawyer. The lawyer will be very familiar with it. And I'm going to let you sign a signature bond since you came in on your own.
Yes, sir.
You understand what a signature bond means?
Yes, sir. I think
It's
so.
just your promise to come. It's like an IOU. I owe you $1,000. I'm going to make it, but I don't have to pay as long as I come forward. And stay away from me.
Yes, sir.
I do have to have you go to the jail and get a fingerprint, because I don't think you got fingerprinted yet, did you?
No, I've not. No, sir.
Okay, that's,
Can I do that this weekend or Monday or when?
you can do it before you get back here.
Okay.
You can just go to the jail anytime, you take this form he's gonna bring to you, bring the buzzer and say, I gotta get fingerprints.
Yes, sir.
And they'll do it, and won't have to stay there, which is a good thing.
Yes, sir.
Any questions you have, Mr. Green?
No, sir.
Okay, be back here on March 27th, unless your lawyer tells you they made arrangements for a different date, any kind of date they tell you.
Yes, sir.
Okay, that's all.
Just wait out there, I'll meet you out there.
That is the law versus Edward Anson. Case number CRA 2624.
All right, sir, you're Edward Anson.
Yes.
Mr. Anson, it's alleged that on November the 11th of 2025, you knowingly obtain, possess, or use methamphetamine. That's a Schedule II controlled substance. That charge is a felony of the fifth degree. Carries a maximum penalty of a year in jail and a $2,500 fine. You understand the charge?
Yes.
You understand the rights you have as a defendant?
Yes.
You have the money to hire a lawyer?
No.
You have a job?
No.
You have no income?
No, not right now. I'm unemployed.
Okay, I'll appoint Mr. Stratton to represent you. We'll need him to come in the courtroom.
Thank you.
Mr. Stratton, this is Edward Anson. He's got a felony 5 possession of methamphetamine. There's a bond up for this. Need probably to have Mr. Hill come in and give us a bond recommendation if there's any additional requirements they want on the bond.
I've seen it, I don't think so.
Mr. Hill, this is Edward Anson. He's got a felony 5 possession of methamphetamine allegation. He's got a bond up. I have a South Point address. Is that correct?
Yes.
Any other conditions the state's asking for on bond?
We would be okay with no additional bond if Mr. Anson were to be assessed for, begin treatment.
You okay to get an assessment? Yeah, yes.
How do you pay for medical services, sir?
I have no insurance.
You don't have a medical card either?
No. They can help him get a medical card.
Yeah, if you're not working, you should be able to get a medical card.
Yeah. Yeah, I've not tried.
Have you ever had treatment before?
No.
What's better for you, to go to Ironton or Chesapeake?
Ironton.
Okay. All right, Taylor wants to talk to you about getting you assessed, and that'll be a condition of your bond, that you gotta get an assessment with Bethesda. I guess that, it's a faith-based burden. Do you have any problem going to a faith-based burden?
No.
Okay. All right, I'm gonna give you 1,000, no, you don't need it, you got a bond up, so I'm gonna continue your bond. Bond's continued, the additional condition is assessment with Bethesda, and if they think you need some treatment, I want you to start that. Then let's come back, is there a time waiver, the typical?
We'll waive time, Your Honor.
What's good for you, say 2 to 3 weeks out?
Looks like most Mondays in March are not good. So
Okay, so Fridays are better. The 13th?
13th will work, yes.
March 13th will be your next hearing, Mr. Anson. It'll be what's called a preliminary hearing at 10 o'clock.
Yes, sir.
Speak with Taylor, and then you're free to go after that.
All right.
Mr. Stratton.
All right, thank you.
You're welcome.
Okie dokie, friends, that brings it to a close for today. I hope you all had fun this week. I know I did. So much so, we'll try it again next week. Monday, 9 a.m. Eastern, 6 a.m. Pacific, half an hour earlier if you're a channel member. Have yourselves a great weekend. Stop by the channel from time to time. We'll post some stuff during the weekend, no doubt, and look forward to seeing you all Monday. But go enjoy your weekend. Take care. God bless.